Good afternoon, ladies and gentlemen. My name is Ronaldo Hilton, the chairperson designee of the New York City Loft Board. Welcome to our February 14th, 2019 public meeting, and happy Valentine's Day to everyone. Section 282 of the New York State Multi-Dwelling Law establishes the New York City Loft Board. The board is charged with overseeing the conversion of inter-multi-dwelling buildings from commercial and manufacturing spaces to safe, rent-regulated residences that comply with the minimum standards of safety and fire protection stated in Article 7B of the New York State Multi-Dwelling Law. To achieve this goal, the board adjudicates and mediates disputes between owners and tenants, tracks the progress of each building undergoing legalization, and prosecutes parties who violate the Loft Law and the Loft Board's rules. Today, we have a panel discussion by Loft Board bar attorneys, David Brody, Jason Frosch, Michael Kozak, and Robert Tucci. In November, the board voted to request some attorneys who frequently appeared on the Loft Board cases to come and address some questions about protected occupancy, including the issues of primary residence and protection for non-prime lessees. Appearing before the board today are the four attorneys I just mentioned. Each attorney will make a 3 to 5 minute introduction, and then I will ask questions that were previously submitted to the attorneys, and we will start with Mr. Brody. Thank you.
Mr. Hilton,
Mr. Brody, could you I just misspoke. Before we begin, Mr. Delaney would like to make a comment.
Yeah, it's asking for an agreement amongst the members of the board. As I've heard frequently from loft tenants over the past few months, the Loft Board minutes, as they've been written up over the last 6 months, have been extraordinarily helpful and easy to read. I know this because people send me questions based on what they read in the minutes, as well as comments. And at the last session in January, where we discussed some of the pending rules, there was significant discussion over the choice of one word versus another, and if the same diligence is applied to those minutes, it's going to end up being 50 pages. And so I wonder if my colleagues would agree that perhaps, give me an example of one of the words we wrestled with.
Overview.
Overview, yes. 15 minutes discussing whether overview was a better term than summary. I would just recommend that the minutes reflect that the board members discussed various terms and agreed on X rather than the 800 words that were expended getting to choose overview versus summary or whatever it was that we did.
Thank you, Mr. Delaney.
Unless anyone objects.
Well, sometimes we didn't agree though, so we didn't end up in a final word, right? We still ended up with some vagary.
There are places where we agreed to have new language come next time.
Yes.
Yeah, that's all.
All right. So, we're saying to the minute takers I know we do good diligence here, but I suppose we can do more summary.
So that one did you?
Yes. Okay, thank you, Mr. Delaney. Anyone has any other comments on it? Okay, very good. Mr. Brody, thank you so much. Mr. Brody, could you please use a microphone? If you could just put that microphone next to you.
and I can speak loudly.
Oh.
And thank you very much for inviting all four of us to come in and speak to you on issues concerning primary residence and how the Loft Board has and will wind up approaching primary residence. My background, for those of you who need a little bit more than the brief summary I gave you in my background, is to the effect that I was admitted to the practice of law in 1979 and pretty much immediately wound up becoming involved with the arguments that preceded the existence of the Loft Law. And since its promulgation in 1982, the Loft Law has been a significant part of my practice, both before the board in the various courts and also with involvement with various of the other agencies that have pieces of this. The context in which the original fights existed, we're looking at the rent stabilization laws and the rent control laws, all of which have a fairly well-defined discussion of what constitutes primary residence. The difference, of course, between what they provide and what ultimately gets provided here is there you have a baseline of buildings that already exist, are already subject to, as opposed to a group of buildings that are all of a sudden being put into a regulatory scheme, and we have to look at the past in terms of a window period to decide how they should be considered and what the criteria for that consideration is. The early cases that precede the enactment of the Loft Board are such cases as Lipkis v. Picus, which looked at the existing law at that point in time and said rent stabilization is the appropriate place for this discussion. And with it, obviously, the requirements of primary residence that also fit into a discussion of who gets to stay and who is a protected occupant. Now, when you look at how the law begins, if you immediately look into MDL 280, you see that part of the initial organizational statement is that as a consequence of the acute shortage of housing as found and declared in the Emergency Tenant Protection Act of 1974, the tenants in such buildings would suffer great hardship if forced to relocate. If you look further on in the statute, you see that towards the end, there's a declaration to the effect that once a building is ready to graduate out of the system, it graduates over to, well, at that point it was the RSA and what was under rent stabilization. And once we got to the DHCR, to that. So in essence, these buildings are a part of the rent stabilization system going through a process that gets them from buildings that have been illegally converted into buildings that are now legal. The early cases that dealt with that, there's Axelrod v. Dixon, which was just about the time the Loft Board promulgated its primary residence regulations, allowing a landlord to go into court if a tenant was not a primary resident and seeking that tenant's eviction based on that. Axelrod v. Dixon, Lester Evans held that the regulations were ultra-virus, and in similar language also looked at what was going on with rent stabilization and rent control and opined similarly as to those. About 2 years later, the Court of Appeals in Lower Manhattan Loft Tenants versus, I believe it was the Loft Board, comes out with a decision that says the primary residence requirements are appropriate for the Loft Board to be written because this is certainly a piece of the law where the Loft law is to be read in pari materia with the requirements of rent stabilization.
Sorry, which year? Which year was that case?
Axelrod v. Dixon or Lower Manhattan.
Lower Manhattan.
It would be 1985.
Thanks.
And if there are any cases I mentioned that people would like copies of, please feel free to contact me after. We'll provide you with copies of anything that we've talked about, and if you want further discussion, that too is available. So what happens at about that point in time? You start looking at the case law that is coming out of the law, and with certainly a certain level of regret, I look back at what my colleagues and I were doing at that time, and the arguments were all about coverage. And the only time you could see a real focus on who a primary residence discussion as a primary residence discussion was as between primes and subs and co-occupants, arguing about who had the right to a particular covered unit. Primary residence did come up in the context of discussions of coverage, and the documentation, if you look back at the decisional law concerning who is...
One more minute.
Got to talk faster. Coverage or not, and, let me skip over a lot of stuff. It was essentially, it was primary residence documentation And you will find that there are discussions such as in matter of middle score 1197, which is Law Court Order 1197, which talks about, how you view conversion. And there's a sort of synergy that on the one end, units that may have been converted physically but were not occupied residentially, except occasionally, were not covered units. Whereas at the other end, if it was covered and there were findings of occupancy, for instance, matter of Mantler, which is LBO 1104, they were covered. And there's a statement, these people occupied the premises during the renewal period. So what happens, Law Board has the same regulations discussing primary residence or on the rent stabilization. And when we go to court, that's what we argue. When we're at oath and hearing to see what happens at the law court, that is what we argue, and that's how we discuss it. Coverage is coverage, protected occupancy is protected occupancy. And the question is, at what points do you look at who should be a protected occupant? Our view, and consistently, and to a certain extent what we are seeing out of oath and ultimately law court decisions, is that June 21, 2010, you have to show that you are entitled to protected occupancy. And you have to continue being able to show that. Otherwise, we've had cases, Mr. Kozik and I at 57 J Street, where he claimed 3 units were covered and the people in protected occupancies. We didn't think so. We registered, we filed for coverage, and we went into court on non-primes. Doing it in one particular location makes sense. We should be able to all do it, because why should there be 2 pieces of litigation ongoing about what is essentially a continuation of a single unit, a single issue, excuse me.
Thank you, Mr. Brody. I'm sure you have another opportunity to be questioned on this, so you can bring some more
The
points.
more questions, the better.
Okay, great. Okay, thank you, Mr. Brody. Next we'll hear from Mr. Just use the microphone. Thank you.
Thank you. I'm a rent stabilized tenant in an former IMD unit that was legalized under the Loft law in 2000. I've been involved with the Loft law since before the law, as the law was being discussed. Once the law was passed, I was active with LMLT and helping to determine what regulations were going to be promulgated to implement the law. I've been LMLT's counsel for probably over 25 years. I've been involved in every amendment to the statute since 1992. Taking up from where Mr. Brody left off, there is one question about whether or not the law board should be considering primary residence in the context of a coverage or protected occupancy claim. Rather than give you my view, I'd like to read for you what this board said in 1994, a matter of 400 West 14th Street tenants. In that particular case, there was no question that the unit itself was covered. There was an issue of whether a woman named Miss Weems was a protected occupant of that unit. The landlord was claiming that Miss Weems had no longer lived in the unit since for several years, even though she had been living there unquestionably on the effective date of the law, which protected her unit, which was the 1987 amendment, which had an effective date of July of 1987. The law court said at that time, the owner argues that Mary Ann Weems is not the protected occupant of Unit 5S because she moved her primary residence outside Manhattan and has filed taxes from her new address. Although the record substantiates the claim that Ms. Weems has not used the unit as her primary residence since 1992, she still was in actual possession of it on July 27, 1987. Therefore, she qualifies for Loft law protection pursuant to the explicit terms of Loft Board's rules relating to subletting, subdivision, and assignment. If the owner believes that Ms. Weems has relinquished protected occupant status because her primary residence is elsewhere, Loft Board rules are explicit and that the owner can commence an eviction proceeding in a court of competent jurisdiction based upon the allegation that the occupant does not use the unit as his or her primary residence. However, it is not the province of this board to render such determinations. Therefore, in the absence of a demonstration to the contrary, Ms. Weems is declared the residential occupant qualified for protection of Unit 5S under the law. That is not an isolated lawful order. That order has been cited countless times in all the protected occupancy cases that have happened since then. And it also is reflective of the practice that the board has followed since the implementation of the regulations in 1983. Basically, it's a two-step process. The first is look and see whether the unit is covered. If the unit is covered, part of that is to look and see has the unit ever been decovered by any permitted means. That permitted means would be a sale of rights, sale of improvements, loft board, finding of abandonment, or return to commercial use. Other than that, it remains a covered unit. Once it's a covered unit, the next stage you look at is who's occupying that unit. If there's somebody residentially occupying that unit, not primary residential, but residentially occupying that unit, and they moved in prior to the effective date of the law, they are automatically the protected occupant. There's no need for landlord consent, there's no need for release, there's no need for anything. Subsequent to the effective date of the law, then you have to have landlord consent. And that's demonstrated by either a lease, or rent payment, or direct dealings with the landlord, or otherwise. Once you have those things in place, that person is a protected occupant. If there is a primary residence issue, based on the regulation that was upheld by the Court of Appeals, and I gave you guys this packet, it looks like this. The LMLTV law court case is in that packet. It's actually tab J and K if you want to look at it, it's a later date. And the case that I just read from the 400 West 14th Street, that's tab C. Once you have that protected status, that person continues to have the right to be in there unless the landlord brings an eviction proceeding based on the law court's rule that was upheld by the Court of Appeals in that case. And that requires that the landlord first be registered, just like any rent-stabilized landlord who would have to bring an eviction proceeding against a rent-stabilized tenant. That they serve that tenant with some kind of notice. In our case, the courts have determined that it's a 30-day notice, and those are the cases that are Monster Realty, Hallmark Art Discount Stores, and Camille Princess, which are M, N, and O. So you have to serve a 30-day notice, and then you can go into court. Registration, 30-day notice, eviction proceeding in court. Exactly like you have to do for a rent-stabilized or rent-controlled tenant. Then what is the look-back period? The look-back period is 1 to 2 years from the date of that notice. Right? Same as a rent-stabilized tenant. In the book, in this packet, I have the rent stabilization and rent control regulations. That's P. That's tab P. It tells you exactly what the standards are for rent stabilization. And it says that you look at the last calendar year and whether the tenant was there for 183 days in that calendar year based on the notice.
Thank you, Mr. Patricia. Okay, thank you. I will now hear from Mr. Fox.
Hi, I'm Mr. Fox, with Steve, and I think like a lot of you here that are newer to the Loft board, and maybe some people that are in the audience that just come to be affected by the Loft law, I started working pretty much exclusively full-time on Loft law cases about 5 years ago. And prior to that, had not been aware that it existed at all. Since then, I've been immersed in the almost 5,000 Loft board orders, countless civil court and Supreme Court cases involving Loft law, and have spent thousands of hours parsing the regulations in every detail, examining every report recommendation, dealing with incredibly complicated trials. So I'm coming at the Loft law a bit differently than perhaps Mr. Brody and Mr. Petrucci are, who combined with spending the last 70 years working in the Loft law. 80 years, I'm sorry. And I think that the questions that have been posed to this panel, other than a few core issues that I'm sure we'll get into, are probably not very strongly disputed. I think what's really the issue that's confronting the Loft board right now, and I think you probably recognize that I've been to just about every Loft board meeting I can make it to in the 5 years that I've been doing this. The issue that you're confronted with is what should change, if anything? And if you're going to change something, how should it change? And those are policy considerations, and not really necessarily contingent on questions of what the law is right now. And the thing that concerns me the most, and I think concerns the members of the board the most, is that, and I think Mr. Delaney had said it best a few meetings ago that it sort of felt like the board was blindly feeling around to try to use the blind man and the elephant metaphor, figure out how to deal with certain issues that they just don't see enough depth in terms of the fact patterns and the nuanced issues that come up in those issues to feel comfortable changing the rules without more information. And that's where I'm hoping this panel will provide for you, a resource for an enormous depth of fact patterns going back 40 years to help understand how a change in the rules and how a change in the law itself might affect the, I think, probably 10,000 or so people who are, probably more, who are living in IMB units, and the owners of those units, and all of the people involved in legalizing buildings, professionals, Department of Buildings, and I'm just hoping that the board will use that resource, ask us as many questions as you feel comfortable asking, to try to understand how little changes that you've all been debating and making in the regs would affect these thousands of people and involved on every aspect of the law going forward. Thank you.
Thank you, Mr. Frost. Our final presenter is Mr. Cook.
Thank you, Mr. Hilton. And let me say good afternoon and happy Valentine's Day to the board. My name is Michael Kozak. I've prepared some comments as well as some submission that I've distributed to the board along with some exhibits, which hopefully you have an opportunity to review. I don't expect you to do that now, but perhaps subsequent to the meeting. I'm a lawyer for Loft tenants, and let me begin by expressing my gratitude to you for the opportunity to appear before you today so that we may engage in what ought to be an open, forthright, and intellectually honest discussion about an issue that has had and will have an enormous impact on the Loft community as a whole. Clear, Mr. Petrucci and I are appearing today as two of about many voices amongst the Loft tenant community. Speaking for myself, I think Mr. Petrucci would share the sentiment, let's speak for him. We are not here today to represent our interests or that of any particular clients of ours. Rather, we are here to speak on behalf of the entire Loft tenant community, amongst whom I believe there is an absolute consensus of opinion regarding the issue that we are discussing here today. That is, whether tenants' eligibility for obtaining protection under the Loft law should be conditioned upon them having to prove that their homes are their primary residences. I do not think it is inappropriate for me to say that the attorneys appearing today are all experts in this field. There are others who are equally qualified to speak to these issues, who I know would have liked to have participated today. And so again, I thank you for the opportunity and for your patient and careful consideration of our thoughts and needs. In preface to my more specific statements today, I would like to take the opportunity to underscore the role that the Loft Board serves in connection with the Loft law. Amongst the most basic and fundamental purposes of the Loft law, as expressed in Multiple Dwelling Law Section 280, is the public's strong policy-based interest in encouraging loft dwellers to come out of the dark so as to ensure that their buildings are brought into the light of code compliance. This interest is at the very heart of the Loft law and is driven by the public's interest in ensuring the health and safety of loft dwellers and the citizens of New York City. Critically, everything that the Loft Board does must, at its most fundamental level, serve this purpose. Whether you sit on this board as a representative of owners or of tenants, of the public or of industry, you are public servants, and your decisions are mandated by the Loft law to serve this purpose. You're going to hear a lot today, including starkly different views of the issue, but in listening to those views, I believe you should ask yourself whether the opinion or view you are hearing advances the fundamental purposes of the Loft law I have expressed to you. I do not think that there is any rational way for you to conclude that the views expressed by our colleagues on the other side of this table regarding primary residence are consistent with those purposes. First, placing a primary residence condition upon obtaining protected occupant status means less covered buildings and units, plain and simple. It creates an additional burden and obstacle for loft dwellers that they must overcome in order to obtain protection. When considering whether to come out of the dark, loft dwellers must consider the risks and costs associated with doing so. They are coming from a place of living in hiding, fearful of exposing themselves to the city and risking eviction. The
primary residence imposition entails enormous cost in the context of seeking coverage and protection under the loft law, given the tactics landlords are and have used in litigation, which I would say have been accurately described as weaponizing primary residence. That cost alone is a strong deterrent for loft dwellers, who frequently do not have the financial capacity to bear the cost to come forward. I have personally met with many loft dwellers who have elected not to seek coverage and protection as a result of this cost and the risks associated with it. When loft dwellers elect not to seek coverage or protection under the loft law, that perpetuates the problem that the loft law is intended to remedy, as those illegal occupancies continue to exist in the dark. That is inconsistent with the loft law. Second, primary residence as a condition of protected occupancy effectively deregulates already covered and rent-regulated IMD units. Presently, the loft board's rules and precedent provide that a loft dweller who is living in an already covered IMD unit cannot seek a rent adjustment or a rent overcharge award if he or she is not a protected occupant under the loft law. In other words, if the unit does not have a protected occupant in it, then it is effectively deregulated, as the owner is insulated from any responsibility to charge the legally required, regulated rent for the unit, and from any liability for illegally charging in excess of that amount. The loft law provides that IMD units are rent regulated by law, yet if an occupant is not established as the protected occupant under the loft law and is deterred from seeking that protection, the owner can effectively deregulate the unit by charging whatever it wants, I'll be finished in just a second, due to the insulation from liability for its misconduct. This ought to give you some idea about why this issue is so important to the owners who are, as a community, opposed to the loft law and to rent regulation. This, too, is directly contrary to the purposes of the loft law. There are, of course, many other adverse impacts from imposing a primary residence burden upon protected occupant status, which we will discuss further today and is also addressed in my submission. Thank you.
Thank you, Mr. Kodak, and thank you all. So we'll now proceed with the questions. In terms of procedure, let me just explain. I will ask the question and designate an attorney to begin the discussion. I will ask that everyone be courteous and not interrupt one another. We will discuss each question, including board members' follow-up questions, for approximately 20 minutes, unless it is apparent that a discussion on that question is over. Then we will move to the next question. I thank each board member and speaker in advance for respecting this process. So, are we ready? Great. All right, first question to the panel. Should a tenant claiming protected occupancy have to prove primary residence of the unit prior to the board granting an application seeking both coverage and protected occupancy status? What if the application just seeks protected occupancy status of an already covered unit? That's clear? Very good. So we'll begin the discussion then with Mr. Coulson. Mr. Coulson.
Well, I think you know my answer. That'd be no.
Why would you say?
Why would I say it? Well, first of all, it's my belief that the law itself does not permit this. The loft law has a provision that addresses primary residence, and I believe Mr. Petrucci will address some of the history around how this provision came into existence. Multiple Dwelling Law 286 2I states that prior to compliance with fire and safety protection standards of Article 7B of this chapter, residential occupants qualified for protection pursuant to this article shall be entitled to continued occupancy, provided that the unit is their primary residence. My view that the statute is very clear. You have to have a residential occupant established. You have to be a residential occupant qualified for protection. That person is then entitled to continued protection, and that continued protection is conditioned upon them maintaining the unit as their primary residence. The statute couldn't be any clearer about this. And, in my view, there's not really an ambiguity in the language itself. Exhibit A to my papers is, Exhibit B to my papers is a letter that I obtained from a lecturer at Hunter in English, he addresses this language. He's an expert with respect to the English language and grammar. There's no other way to read this. The language is clear on its face. So, and the way this is intended to work, it's that you get the protected status, then you must maintain it as your primary residence. The landlord may seek to evict on the grounds that it's not your primary residence, and that's in the law court's rules. And that's consistent with the Court of Appeals decision in LMLT and the law court, and I think, again, Mr. Petrucci will address this, but that provision was put into the statute in order to codify the rule with respect to seeking eviction of tenants that was challenged in the LMT against the law court. So I think just as a matter of just the statute itself, I think the law court is bound. There is no ambiguity in the statute. If the statute is clear as it is issued, then the law court has no discretion to do anything other than that.
Thank you. And open up to board members. I recognize
Just
Mr. Ross.
ask for the actual number that you're citing in the statute.
The statute
Yeah.
is multiple dwelling law 286, 2i.
It's, if you want to look at it, it's tab I on that packet that I
I've
gave.
got my own statute.
For those of you who don't have your own, it's tab I.
I would just like to make a short statement. Starting with the artist moving in Loft Art in 1960, where they were in fact hiding in personal beds and things like that. Artists have been enormously fearful of being evicted. So much so that when Chuck and I attended a meeting last week, a week and a half ago, about the rezoning of Soho No. The planning commission had said the meeting didn't have enough chairs, there was no microphone. Hundreds and hundreds of loft dwellers, most of them tended to be older people, were there because they're still fearful. And as a corollary to that, it is the fact that the arts industry in New York has helped make New York what it is. And there is no question about it. So that's, essentially, that's sort of my bottom line about people being evicted. And of course, everybody in those lofts are not artists, but the majority of them are, and I use the word fellow traveler as somebody involved in the arts. It is so important that these people maintain their residence.
Could you clarify what you just said? You said something about being bottom line, people being evicted. What is the bottom line?
Well, the bottom line is the fear that artists have, even those that have been in Soho for 30 and 40 years, are still fearful.
Okay, thank you. Thank you. Is there another board member for a question?
I would just inquire to either Mr. Frosch or Mr. Brody, what is your response to what would take place if the answer to question number one is indeed no?
Let me pull question number one and look at it so I remember what it is I'm
I
answering.
can read it for you.
That would be
Should a tenant claiming protected occupancy have approved primary residence of the unit to the board prior to the board granting application seeking both coverage and protected occupancy status? And what if the application just seeks protected occupancy status of an already covered unit?
Okay, let me, breaking it into two pieces. Our view has always been that, our view certainly since we realized that we ought to have a view other than sort of the casual view that preceded the enactment of 2815, has been that protected occupancy is an issue both as to what is occurring on June 21, 2010, as well as what is occurring at the time that the applicant files his application. Rent stable, protected occupancy is not something that you turn on and turn off as a matter of convenience. It's a matter of there is an emergency, and if you have a certain qualification, then you should be subject to protection. And, for instance, if you look back at Mel Dixon, who preceded all of this, he was a photographer. He lived upstate with his wife and his children, and he had a studio in New York City where he'd come a couple of days a week and work, and then go back to his wife and his children up there. Now, if you look under regular rent stabilization, and, ignoring all the paperwork and the taxes and that sort of stuff for the moment, is he a person for whom this emergency declaration applies? If you look at most of the tenants who were claiming that they were entitled to protected occupancy, and if you look at what happens in many of these cases, we settle out a lot of these cases. And the reason we settle out a lot of these cases is because we wind up at oath, and, the tenant brings in and shows, once we get past the issue of coverage, one way or the other, and shows us documentation. And we look at the documentation. And sometimes the landlords will say, I'm covering the rest of the building, I don't really care, cover the building, cover the tenants, we'll deal with it. Other times, the landlord may be a little bit hesitant, but the tenant has his taxes from New York City. He doesn't have a residence someplace else, and we turn to the landlord and we say, hey, look, this is a good place to resolve whatever issues you have, because we can do a trial and we can drag this out, but this tenant, the building is going to wind up being covered, and the tenant's going to be winding up covered. And while Mr. Kozak has his view of what landlords want, it's not particularly a true view. If you look particularly into what is happening in Brooklyn, since the original law, a lot of these buildings, as was the case in Soho, became obsolete for manufacture. And the reason these landlords got involved with what they got involved with was because there was no income otherwise. I was in a case that's supposed to be somewhere in the early 2000s. I'm representing the landlord in Supreme Court, dealing with a group of tenants, and this realtor is there and they're talking and they're chuckling because all of a sudden, property in Bushwick had a value again because you could put residential tenants into it and it could work out. So, the theory that landlords hate residential tenants and don't want them, it's not a good theory. Does it make their lives more difficult? I don't think there's a whole lot of question, but that it does. But on the issue of, are these landlords all, just absolutely adverse and looking to get rid of tenants and just to be bad guys about it, I think the overwhelming answer to it is no. And I think you go back to looking at it and say, what is the purpose of the statute? The purpose of the statute is to provide protection to people who need protection. What's the first point of looking at that? June 21, 2010, and we may have another point in a few weeks to a month, but June 21, 2010. And all of a sudden, you have a Loft law that becomes effective as of that date, looks to what's going back 2 years at that point. And I've had discussions on that. And essentially, if you sort of look at it, in a slightly more amusing light, it's kind of like the Big Bang Theory, where a moment before there is nothing, and all of a sudden there is something. And at that point in time, all rights, obligations apply. And if you look at all rights and obligations, the rights and obligations as to landlords apply without question as to what they wanted and as to what they intended. And the rights and obligations is there a particular reason why tenants should not be at a particular standard.
Mr. Brody, could you just, I understand, but you just wrap it up. So he has
Okay.
some more questions.
Okay, but basically, the reason that you have a window period is to look at what, is to all of a sudden tell everybody, here's what the law is today. And we need to see what you were doing back then, to know what you were doing at a point where you had no reason to fabricate anything, and to see therefore what it means to us at this second and going forward.
Okay, thank you. Does any board member have any questions, or would any of the other attorneys want to comment on that?
I have a bunch of...
Yes, Mr. Carr. I'll give the question in prior, yes.
Well, I would ask the attorneys for the owners to comment on the statutory construction argument that Mr. Kozak has made. In essence, he's saying, notwithstanding the phrase primary residency in the statute, an occupant should not have to show primary residency.
Sure, I can respond.
I think if everyone on the board could just
Excuse me, can we just ask for a timeout? There's a camera angle problem with these seats. It's not that the lady in the front row is saving them all for her
Thanks.
friends like a movie.
There really aren't any more seats, that's the thing.
Well, there are front seats.
No, they all are, they all,
I mean, give it a try, go ahead, sit. If you don't mind your head being in YouTube, forever, it's okay.
I'm on it, having said.
Okay.
Thank you. So if you take a look at that section in 286, it's number 2 sub little I, and you read it for yourself. And this is the first time the board has dealt with this. In fact, I remember maybe less than a year ago, there was a presentation by the law firm staff about this very issue. And it was hotly contested and debated, and I was watching that meeting in the audience, and it seemed pretty clear to me that there just was not a strong argument about 2I requiring primary residence be maintained in order for protected occupant to be in continued occupancy. And it is a meaningless academic parsing to say, well, first they have to qualify, and then an hour after the ink is dry on a loft board order, then the landlord can go into a non-primary residence no longer. This is a massive waste of your time, the judicial resources involved in commencing a second procedure, and it creates an even more expensive litigation position for all of the parties involved. The statute is clear. It says you have to use it as your primary residence. And not only that, the cases that Mr. Brody was discussing, including Lower Manhattan Law 10 versus Law 4, reiterates that primary residence is a requirement in part based on the fact that there is a housing emergency. There's not enough residential units to go around New York City, and it is inequitable to the people who need housing to permit people to have regulated rights in IMB units who have a primary residence elsewhere.
Thank you, Mr. Brown.
May I respond?
You're going to get a chance. I just would like to hear from Mr. Patricia.
Yeah, that section of the law was put in there by Don Leibowitz, who is the Assembly bill drafter. So somebody on our side of the table, right? And it was put in specifically to codify the Court of Appeals holding in LMLTV Law 4, which had happened 7 years ago. He told this to Chuck, and he told this to my partner Ray Bailey when they were up in Albany at that time. They consulted with me as they were consulting a lot about the language that was happening with the law at that time. Mostly it revolved around creating a new timetable, extending the law, which was about to expire for the 3, 4, and 5 unit buildings, which was half our universe at the time, so we were very concerned about that. And the issue of adding the legalization milestone increases. That was the major focus. The issue of primary residence was nothing, was not even a concern, because all it was doing was codifying what the Court of Appeals had said. And what the Court of Appeals said is, we are upholding the law court's right to issue an eviction regulation that requires a registered owner to bring a proceeding of non-primary residence in a court of competent jurisdiction. Because it's in pari materia with what rent stabilization and rent control do, i.e., bring an eviction proceeding after notice in a court of competent jurisdiction.
Thank you, Mr. Patricia. I think that's Mr. Bush. Go ahead. If it's different.
It is different. I think that Mr. Frosch is misconstruing what I've said. I think Mr. Carver misconstrued what I said. I did not say that provision of the statute does not require somebody to maintain the unit as their primary residence. What we are talking about here today is whether you must prove that the unit is your primary residence in order to obtain protected occupant status. The statute, seems to me, defines This is a term, it's in various provisions of the law. A residential occupant qualified for protection. That is a defined term in the statute. It is in the regulations. Statute refers to that entity, that person who is already qualified. It says that once they've got that status, then they must maintain it as their primary residence from that point forward. That presumes that you have already obtained that status. Seems to be pretty clear what I'm saying here, which is that, yes, there is a primary residence requirement, but after you've already obtained that status.
And could you just clarify, how do you obtain the status?
Bring an application for protected occupant status. The law court's rules currently require that in order to obtain protected occupant status, you must be a residential occupant of the unit. There is nothing in the law or in the law court's rules that says that somebody who is not in actual occupancy of the unit would be able to obtain that status. The rule itself says explicitly, you must be a residential occupant of the unit. In order to establish that, you put forward proof to show that you residentially occupy the unit, some documentation that establishes a connection to the unit, and perhaps testimony if necessary. But that is a qualitatively different analysis than having to prove that you're primary residence, which requires, as we've seen in many cases that I've tried with Mr. Brody and Mr. Frosch, where they want discovery of every single possible document that exists out there with this person's name and address on it. And if there's a bank statement that has a transaction on it, they're going to ask them questions about virtually every one of those transactions to determine where they were on a particular day and what they were doing at that particular day and why they were in that particular location. That is different than putting forward some documents that show that you have a connection to the unit to establish that, just as a baseline matter, that you residentially occupy the unit, which would qualify you for protected occupant status under the law court regulations.
Thank you, Mr. Bowden.
I would like to.
Mr. Brody, 1 second. I'm going to allow some board members to ask questions.
I had a question. I'm wondering, you were talking, it's great to have these older cases. Is there a trend or any information you could give us on more recent cases from the 2000s or since the 2010?
I can tell you that the cases have been identical to all of those until the board changed its mind in 2014 or so. There has never been a case that required primary residence or protected status prior to 2014.
And if I may.
Is there a case for 2014 that I should read?
Or might have been one of the earlier, I can't remember what.
Matter of Cohen, 2013 was the last decision that I'm aware of that didn't require it. In fact, rejected primary residence
And I think
as part of the analysis.
matter of Mariner Smith might have been the first one that the law court actually adopted that enshrines primary residence as a qualified criteria.
That was
And
without any discussion, without any change in rule. It just sort of appeared from proposed orders that were offered to the board that you guys eventually
Great.
adopted.
We have 1 more minute.
If I may, there are a number
Kind of a
of...
loss. I mean, we were at kind of a loss at the time.
Yeah,
right?
I mean, there are a number of cases that are pending before the board where the issue is raised and is discussed, and where the judges at oath make decisions, saying, this is the standard to be used, and this is what we find. And at least one of the problems that we have in going forward is that we're waiting for decisions to get instruction as to what we should be doing and as to what we, whether what we think is correct or incorrect. One of the other things that, is out there, and it's in a number of decisions that we are waiting to see what the law court's going to do. One of the things that happened over the last few years, and I think sort of, notwithstanding Mr. Petrucci's opinion as to what the earlier law is, I think the court decisions that have come out over the last 5 or 6 years have really changed how we have to look at these things. For instance, one of the arguments, and Mr. Petrucci and I certainly got to go at it in one of the cases that will eventually get to it, is the issue of...
No.
I'm not going to
pending
discuss
matters.
facts, I'm just discussing law.
Okay.
Which is why I didn't name the case also. The Ansonia versus Unwin line of cases out of the Appellate Division First Department, which basically say, the law does not extend rent regulation to people that take a position in their income tax that is contrary to the tax returns that they are filing. And we don't just mean, they use an address for the return that's different. What an Insonian, what in that line of cases talks to is how you declare your income. Are you declaring, that you live somewhere else and that your unit, is a business and you're taking 100% rent deduction from it? And, that's what Birnbaum went to, and it said, the court says, in that one factor, that's the answer to it. And they followed Bianca Jagger case, which had said, there's also another circumstance where there's just one factor, and that one factor is whether your resident status in this country permits you to have a primary residence in this country. And if you look at that in the context, most recently in a case that Mr. Kozak and my firm have been fighting about for a significant amount of time, Goldwater v. Amicus, his client, who wound up withdrawing his law board application with prejudice after never producing any documentation, they start a Supreme Court action to get a declaration that he is rent stabilized in his law. And the appellate division comes out a few weeks ago, and admittedly, Mr. Kozak has made a motion for leave to go to the Court of Appeals on it, and they say, the law does not extend the protection of rent stabilization to a person not using the subject apartment as a primary residence.
Okay, we agree.
And moreover, and then, cites to Mahoney-Buntsman, which is the base, the Court of Appeals base. But what that says,
Thank you, Mr. Brody.
if you can't extend the protection, where's the protection ever, and why don't I get to argue it both as to 2010 and as to the point at which a person makes an application?
Thank you. Thank you. So that is the end. Actually, we've gone over minutes.
I have an important question, very
Yeah.
important.
Okay.
So the main problem that I have, and I think many members of the board will have with this concept of the primary residency question being adjudicated in housing court, is that this board cares about the definition of what a primary resident is. And if it's adjudicated in the housing court, we would lose control over that definition. If it's adjudicated in the law court, we have the ultimate say through our case law. And we would lose that ability to control the definition if it were adjudicated outside the law court.
Is that a question?
What are your thoughts?
I have a thought. Primary residence is a legal standard. It's not something that the law court can somehow decide whose primary residence like. It's either primary residence or it's not. I don't understand how you think that you can decide what it is and how you're going to apply your cases in relation to a term that is well set.
Well, I certainly agree with you on that small issue, although that's not the opinion, I think, of most of the board members or our staff.
Okay, Mr. Can I just, yeah.
I could address it.
You can address it maybe in the next question, because it's really a follow-up, right? Okay, so that's the end of the question for question one. We need to go through it, and of course, if time allows, we can say anything you want. As to question two, if the answer to question one is yes, right? During what time period should a person have to prove the unit was their primary residence? And I suppose we have 20 minutes, and that should not take that long, so we can always answer. So we'll begin.
So let me just say that as of right now, the answer is yes. Under the current state of the law, is beyond dispute at this point that the answer is yes. Now, if you're asking, should it be yes, that's a totally separate question.
And that was question one. We're saying if your answer to question
I'm getting there. I'm saying the answer to the first question was it should be yes. And so moving on to second, I just want to take issue with the fact that it's if yes. It's yes. But during what time period the person should have to prove primary residence? It should be from the date they moved in through the date of the closing of the record, or the date of the effective date of the law to the closing of the record, whichever is the later period. And this is actually addressed in the Goldwater versus Amicus appeal that Mr. Brody referred to, and we passed around the transcript of that whole argument. The argument in that case that Mr. Kozak was making on behalf of Mr. Goldwater was that his failure to be able to show primary residence because of tax return conclusion, should it matter because there's a limited period of time, and only that limited period of time of the dollar period should apply? And I think 3 at least of the 5-judge panel were extremely skeptical, to say the least, of that concept, and repeatedly questioned skeptically, why should it be that a person can have a lease, not use it as their primary residence, and then just come in a year later, a year and a half later, and suddenly start using it right before that period, and then claim they have the continued right to occupy it as a rent stabilized suite.
Mr. Fresh, can you just clarify, this case, if I understand what Mr. Brody said earlier, never came before the law court?
Well, it did.
It was withdrawn?
It came before the law court as a denial of a motion to withdraw without prejudice and the granting of a motion to dismiss.
I'm sorry, that's just inaccurate. This case was never before the law court. We're talking about an action in the Supreme Court regarding a claim for rent stabilization.
Well, I think maybe you were misunderstanding. So that this was a law court case, and there's a law court order dismissing Mr. Goldwater's claim, and then there was a Supreme Court action to declare for a judgment, and this was the appeal of the determination.
So it was on our summary calendar?
Pardon me?
It was on our summary?
Yes.
No, it was on the master calendar.
Sorry?
There was a decision by Judge Casey. We registered most of the other units in that building voluntarily, and we just couldn't get any discovery out of Mr. Goldwater. And so push came to shove finally, and at a certain point, a motion was made by council to withdraw Mr. Goldwater's claim without prejudice. We opposed, we said it should be with prejudice. The decision was that it should be with prejudice. It came up to the law court, and you accepted that decision. Thereafter, Mr. Kozak commences a Supreme Court action claiming that he should be subject to rent stabilization. And that is the first time that we got to see Mr. Goldwater's taxes and to deal with it. And the result there was, in the lower court, summary judgment saying that he is not subject to rent stabilization because, and the appellate division, do I recall, was a unanimous decision?
Unanimous.
A unanimous decision to the same effect.
Okay, thank you. Anyone else?
Oh, just one more thing, sorry. Date moved in to the closing of the record, or date,
Yeah, maybe you could just clarify that it should be.
that's your interpretation,
The
but
effective date of the law forward, but obviously if someone were to move it after the effective date of the law, then you wouldn't be looking at the period from when they moved in backwards.
And I will say also in that context, and without naming any cases, you know, the litigation on the issue at both has been robust. You know, and we wind up, in some cases, arguing to the end of the record and with proof to the end of the record. And again, this is something that you will get to ultimately decide. We have a particular view. We think there's a logic to a particular view. The tenant attorneys also have a significantly differing view and with a very strongly held opinion as to that differing view. You know, and you know, the issue here is not one of good faith, bad faith, but how do you view the statute? How do you view the requisites of the statute? How do you view what is to be done in order to give the theory behind the statute a real and a true meaning?
Okay,
I just want to refer to the matter of Hughes' decision that I think was just decided, reconsideration was denied maybe 2 months ago, 3 months ago. And I want to say it was a 7-2 decision to adopt the proposed order denying reconsideration. And that was a case where the tenant admitted on the stand at oath that they had stopped residing in the unit, and that period of time during the pendency and in the middle of trial was found to be relevant for purposes of showing lack of primary residence.
So, yes, thank you. So, in order just to focus on the question, I just wanted to hear from the other 2 attorneys, understanding the difference of opinion on the question here. But if yes to question 1, then what time period should the person prove that it was their primary residence? Just if you have any. I understand you don't agree with it, but
Sure, understood. Since the Goldwater v. Amicus case has been discussed in some length here today, I have no idea why. It has no relevance here. That case was in a rent stabilization context. It was not as a result of any Article 70 brought from any order of the law board. Completely irrelevant. It's separate litigation. But since we're talking about it, the reason that the panel at the appellate division was skeptical of Mr. Goldwater's claim was because he was seeking a renewal list in that case. And the appellate division said, well, he wasn't maintained as his primary residence, and so he's not entitled to a renewal list. So I think that ought to address the Goldwater decision. I think it's been really misconstrued, and the facts are misstated, and it has no relevance. With respect to the primary residence issue, if the question is, are you a protected occupant? The question is, right, it's going to be, is it your primary residence? Is it currently your primary residence? That's the determination. When you file your application, your obligation, I suppose, would have to be to have it be your primary residence at that point in time. Now, in the rent
At the time you file the
file your application. I mean, if it's going to be from that point forward, then you just have this sort of ongoing obligation to produce discovery that will just be endless until the time of trial, which doesn't make any sense. It should be when you file your application, you have to show your primary residence at that point in time. And and I think that this is basically how it's dealt with in the rent stabilization context. Yes. Landlord brings a case against a tenant, say, well, it's the landlord's obligation, by the way, in the rent stabilization context, to prove it's not somebody's primary residence, not the tenant's burden to show it is. The landlord has to show that.
Can I just follow up with you? What if the application, you're talking about an application that seeks protected occupancy status. What if it was seeking for coverage? What would be your position on that?
Well, it's an interesting question because it's well established by Court of Appeals law that you don't have to show that the unit was occupied as your primary residence in order to establish coverage for the unit. So, but at the same time, you would have to prove that you occupied it as primary residence in order to get protected occupancy status, which are, sort of conflict with each other. I wouldn't say sort of, they do conflict with each other. But if you're trying to show that it's you're entitled to protected occupancy status, I think it has to be at the time that you're seeking that protection. And there is in the rent stabilization context a look-back period, right? In the rent stabilization context, you're going to look back at the history of that tenant's usage of the apartment, right? Are they using it the majority of the time? And what their documents are that connect them to the apartment to determine whether or not it's their primary residence now. And so you're looking at the history of the tenancy to make a determination as to whether it's your primary residence at this point in time. And so I think that it doesn't make sense to have to prove it at any later point. You should prove it, as of the point that you file your application and bringing that forward.
So, Mr. Petrucci?
If you look at tab P, the packet that I gave you guys, there's the rent stabilization and rent control regs. And they have a definition of items to look at for primary residence. And one of the things they look at is whether in the prior calendar year, the tenant was staying in the apartment 183 days. So, but that has a specific triggering point. In the rent stabilization context, it's when the landlord sends a notice of non-renewal of the rent stabilized lease. In rent control, and even in the loft context, it's when the landlord sends a notice of termination. So whatever happens subsequent to the notice of termination is not really significant. You look back, the calendar year, about 12 months before the notice was served. And so that would make sense if you were going to do something with primary residence. It seems like there should be a parliamentary with what happens in rent control and rent stabilization, so that there's a look back period of maybe a year after when the application's filed, and that's it. What Mr. Kozak was talking about is having this rolling obligation. This case has penned an oath for years, and to have a discovery demand every 6 months asking for more documents and more documents and more documents. What Mr. Brody was talking about before about us, we do settle a lot of cases. We've just had a tremendous fight in two particular cases where primary residence was an issue. If we were only talking about residential use, we would have settled those cases. There was no question that we would have settled those cases. They would have been over and done.
That's a fair statement.
And then the landlord could have then, registered the building, brought the primary residence challenge in court, just like the law enforcement provide. And we spent, what, 15 days?
20 days for most.
There were others in the case, but the real bulk of the hearing revolved around primary residence. And that would have been eliminated, we would have stipulated on that if that was not required.
I'm assuming both Mr. Petrucci and Mr. Kozak have the same position on this. So, Mr. Kozak, you mentioned, I asked you about the primary, at what time, and you said it was at the time of filing. So, any continuation? Do they have to continue to, do you have the opinion that they should continue to live, or continue to have protection, to be the primary residence continually after filing the application?
In order,
Yes.
just to clarify the question, after the application is filed but before adjudicated, that the
Yes.
tenant has to continue to
Yes.
show?
Yes.
I agree with Mr. Petrucci that that's, it just doesn't, practical matter doesn't make any sense that would be the standard, because it would impose then this continuing discovery of burden.
What about, what if someone just files and moves?
They have to be residential occupant of the unit. But if they're not occupying the unit, then they're not going to get protection. So I mean,
Are you saying
if
they don't have to be primary residents even after filing and in order to continue protection?
No, occupant.
Just occupant.
Occupant. If a landlord asks a tenant, are you occupying the unit? And they said, no, I turn the keys over to the landlord. They're not gonna get protection.
Okay. Board member, any other? We have 6 minutes on this question. Mr. Roach.
If we have a little, okay, so I'm not exactly sure. I think this is a good time to interject this. I go back to what my colleague here brought up in the beginning, and I believe it ties in with what period of time and the feelings of what the occupant should do. Can you give, I guess this is directed to Mr. Petrucci and Mr. Kozak. There was discussion about fear of loft tenants in even coming forward to request protected occupancy status. And there was some discussion that people have lived in that fear for decades. Obviously, you would expect this question to come from the fire department, because we don't believe anybody should have to live in fear. I don't believe any living thing should have to live in fear that they may not be able to have a place to lay their head down. But I would like to get a better sense of the number of, to the best of your professional opinion, the number of people out there living in loft buildings that you believe are not coming forward in some capacity because of a sense of fear. And the second part of my question is, I would like for you to present 2 examples, not mentioning the proper names or addresses, that Mr. Petrucci and Mr. Kozak have encountered where tenants have said to you, through association or what have you, I'm just not coming forward because I'm afraid.
There are an incredibly large number against,
What
much of us say.
With all due respect, what's
I must say
incredibly
against
large?
my advice. When somebody comes to me and I feel that they have a case under the loft law, my advice is you need to go for it, and you need to go for it now. But many people don't have the financial wherewithal, they have other things going on in their lives. They're concerned about the inspections, what's the legalization going to cost, things like that.
But that's not fear.
Well,
Fear is, I'm afraid that if I say anything about the conditions in which I'm living, that I may lose the
I was just about to
conditions.
get to that.
Okay.
That people are concerned, and it has happened, even in buildings that have been applied, where the fire department or the buildings department has come and issued vacates or partial vacates. and they've been lifted, and then they've come back, and there's just more vacates and partial vacates. And people are constantly dealing with this, because the conditions that are causing the vacate are not being corrected by the landlords, and the tenants can't correct those conditions themselves.
Okay, I've gone on record as saying this quite a few times, and I was debated at least one time, but in the roughly 4 to 5 years that I have been involved in the Loft Board, I know of no time that the FDNY vacated any loft tenant from their building. There was one time that the FDNY was involved, but another city agency actually did the vacate. So I keep hearing about fear, I keep hearing about fear of vacate, but I've yet to have anybody provide me with any statistics or facts that show me that it's actually happened.
I mean, maybe we can figure out a way to do that. I don't feel comfortable doing it in this.
No, I'm not asking, I'm just saying,
I'm happy to talk to you.
I don't want
specifically.
anybody to live in fear anywhere in the country, let alone the 5 boroughs in New York City that I'm sworn to protect. And if this is a problem, we need to work together to try to find out how we can make that better. But I have repeatedly, not just today, but I keep asking for facts, I keep asking for numbers, and I'm not getting anything.
Well, it's hard to.
And I have the facts and the numbers that can show you how many times the New York City Fire Department has vacated a loft tenant. And I'm telling you that to the very close best of my ability, it hasn't occurred in the last 4 or 5 years. So somewhere along the line, the attorneys, the tenants, the board, we all have to get on the same page here so we can put this fear factor aside. I'm starting to see strides being made to where tenants are actually coming forward. Walls are being broken down and tenants are coming forward to the FDNY because I believe that in my time on the board I have fostered an element of trust. I'm being asked to come visit some of these folks. An element of trust has been broken. I want to continue to make my tenure on the Loft Board one to where those walls are breaking down and the tenants are not afraid to come forward with the things that they're concerned about. And I would ask that we all work within the context of what the chairman and the board's trying to accomplish here to make that one of our paramount things.
Greatly appreciate that. I do tell my clients when they're having issues, to actually go to the local fire department and tell them that they're there, tell them what's going on. And that sort of takes the pressure off if something does happen in the future. But there are specific instances, and I don't know how to convey them to you without being specific.
Well, you can make up an address, 672 Jackson Street.
Oh, you just want me to tell you the story?
Mr. Jones has told you that he's afraid.
I thought you were looking to find out where the...
No. See, that's part of the fear thing. But if we make up, George Jetson, lives in a spaceship in Brooklyn somewhere or something like that.
Can I ask?
The point simply is that I'd like to have some factual information.
Are you saying the fire department's sort of a safe space where you can report issues?
I'm sorry, what was the question?
I mean, are you suggesting that the fire department is a safe space where you can talk and not fear that you're going to be...
With all due respect, I kind of don't want to divert.
Yeah, we need to get on track.
We can talk about that at any point in time.
And by the way, the Loft Board is a safe haven.
We're all the safe haven.
Loft Board.
I just hadn't heard that before, so I was
The Loft
curious.
Board, and we do, and with all due respect, I don't mean to go off, I'm trying to integrate it back into this point of discussion here, but the Loft Board works with all the agencies to provide health and safety for the tenants in the city of New York. So, and they all kind of communicate with the Loft Board before any action is taken. So, he could do a good job at that, and that's what he's trying to say. All right?
And so that, to me, seems like a much more gnarly issue where you start to get into building code, but like usually the the vacate orders come because of some life safety issue, which is not what we're talking about today, which is protected occupant, right? And then whether or not landlords have done work or tenants have done work or exits have been blocked and those kind of things, and that's a much larger discussion.
But what we are talking about here today is what period of time. The question says during what period of time. Whether that's what period of time approved, what period of time, etc. I'm only playing off of what was stated in the first question, is that people have lived in fear for 30 years. Okay? So I think it's extremely relevant, that we have some sort of facts. And I still haven't heard anybody say, well, I would estimate that there's 400 loft tenants in the city of New York who are living in fear. I just hear people say somebody's living in fear. Well, okay, how many people roughly, and what are some examples of what they are telling you so that this board can correct those situations? And only, gentlemen, only with all due respect, unless they come to us as a law board, which the allegation is they're afraid to do, are you going to be able to help us to fix that? Because if you're hearing that through your associations, or you're sharing a meal at a club and you're talking with other attorneys, only you have that information. If the people are afraid to come to us, which is supposed to be their safe haven, we can only rely on both sides.
I would not know tenants who are not coming forward.
Okay.
Simply because that's not my side of the
Okay,
business.
sorry, I'm going to curtail that part of the discussion here. I think we've kind of went off track a little bit. So we need to answer all the questions, and then of course we can go into other stuff if you don't mind, right?
I don't think we got the answer to the time period from the owner's side. I don't recall.
I did.
Yes, Mr.
Yes,
Frost
we did.
spoke
We were
on it.
very clear on it.
And
Okay.
actually, he and I share the same opinion, not too surprising.
Okay, very good, thank you. All right, so moving on to question number 3. And by the way, now I can make a pause here if anyone needs a break. You good? All good. All right. If yes to question number 1, which of course we've got to go back to question number 1 for claiming deck documents, right? If yes to question of what evidence then should the board consider in determining primary residence? So if the answer is yes, what are the evidence that the board should be looking for claiming primary residence? And I will start with Mr. Tucci.
Well, I mean, no one factor would be determined. You have to look at the entire record of the case. That's how the standard is in housing court, that's what the standard is for rent stabilization, and then that's how we've always litigated cases.
Okay.
You don't look at one particular.
Thank you. So this is actually a multi-part question. So as you answer, and I'm going to let each member answer this question before I turn it over to the board, just to get you guys a chance to all say something. Should the board adopt the standard by housing court? Yes, no.
Well, I think the answer is yes. I mean, that's how we've always litigated. That's how the board's regulation is worded. The J1 regulation, or the used to be J1, the eviction regulation. That's what it would have to be. Like I said before, and Mr. Carver pointed this out, I'm not so sure how the board can develop a concept of primary residence that doesn't conclude what primary residence always has been.
Okay.
That's why I think residential use or residential occupancy, which has always been the standard that this board has applied until recently, is what we should continue to go with.
Okay. So just to be consistent, should the board adopt a more flexible standard, I guess, given that these occupancies differ from regular rent-regulated apartments?
Well, they should.
You said yes to the other, so I suppose.
They should. I mean, if you're talking about primary residence, I don't think you can.
Okay.
I think, yes, the board should adopt a more flexible standard. It should be the standard of residential occupancy that had been the standard for 30 years.
Okay. So you're saying that those standards have changed even in the housing court?
No, they haven't changed the housing court. They've only changed here.
Okay. What types of documents should the board be looking for to make these determinations?
there's an incredibly wide range of documents. If you get a discovery demand, I don't know how you could limit if you're trying to prove primary residence. And I keep on coming back to, if you're assuming the requirement of primary residence, you're going to have a problem with limiting the documents. So that's why you should stick with what you had before, residential occupancy in those cases. We cited, David and I would have stipulated to those cases.
Very good. Mr. Kozak, do you remember all those questions that was asked?
I do.
Yeah, go ahead.
The standard, as expressed in various cases addressing primary residence, is substantial physical nexus with the unit for actual living purposes. That's what's in the cases. And in the rent stabilization code, it speaks to the various factors that Mr. Petrucci alluded to, and to determine that issue. How do you satisfy that standard? It's the standard in the courts. I think that I agree with Mr. Petrucci that it would be difficult for the law court to formulate something different. And I haven't seen that in the proposed rulemaking. There's different standards. So I think what you're asking about is what are the factors that you look at in order to satisfy whatever that standard is going to be. And again, I agree with Mr. Petrucci that it's from our standpoint, we're litigators, and the standard is always going to be relevance. Is it relevant to the determination? And there is a pretty broad standard for relevance. Is it even likely to lead to relevant information? That's pretty broad. So that allows landowners to go pretty in-depth. They have the right to basically look at any document out there that has that person's name on it and their address on it, or that may otherwise indicate that person's connection to that address or to another address. And this is exactly what we've been talking about here, is that burden is what is creating this cost, this deterrent for tenants, because they unabashedly seek every single document that they can in order to determine that standard.
Okay, thank you, Mr. Park.
And we're going to get to that. I think we dispute what Mr. Kozak just said about discovery, and like I said, we'll talk more about that. That's not what's happening in terms of discovery. But I agree that certainly the standard is anything that's reasonably likely to lead to a discovery of relevant information is permissible in terms of dealing with the issue of primary residence. In terms of the question, what are the factors? I believe it was a matter of Lopez. Its law court order 4533 was decided in June of 2016 by the law court. And it specifically states that the rent stabilization code factors are the factors that should be used for assessing primary residence at the law court. So it's the same standards, the same factors, I just don't think we really have much of a disagreement in terms of the application of the housing code standard to issue primary residence here.
Thank you, Mr. Brody.
And I think, the thing that needs to be added to that, yes, the housing code standard, the appellate division, the Court of Appeals standards, are all what we have been using in our fights at home. The one change that has occurred is really with the Ansonia Unwin decision and its interpretation. Generally, the standard is no single factor may be solely determinative, with the caveat that is Ansonia Unwin in the cases that follow it, and Mahoney-Buntsman, there are two circumstances where a single factor is determinative. And one is, what you do with your taxes in terms of taking business deductions and declaring yourself somewhere else. And the other one, which is the Bianca Jagger case, is, if you are here and you are on a visa status where you are not permitted to have a primary residence or a domicile in this country. Those two situations, that one factor is determinative. Otherwise, the question is what matters. I mean, for instance, one of the things that comes up regularly, and at one point I thought I had a great epiphany in a case. In Williamsburg, there are a lot of people, where I'd be doing a public database search, and there was an address on Bedford Street that would come up as being their address during a particular period of time, and indicated, as an address, right below whatever the building address they were claiming to live in was. And, great, wonderful, I got them over. No, it was a mail drop. And I regularly get testimony or a discussion that, the reason we use this is because there are problems with security of the building, I can't get mail here. So that's a factor that, if it were in a different context, is a factor that matters. And you just look, what is this person's life? What do their documents show you? How deep in do I need to go? If somebody, if I do a public database search and this person shows up as, this is the only address they've ever been at for the last 20 years, they vote here, their driver's license is here, lease is here, I then, have my usual discovery demand, which hasn't particularly changed from landlord tenant court to here over the past decade, and I say, can you give me, what do you have that you can show me that, will make this a definitive thing? And, we get there and, if I can, and there's no question that this is the only place this person has ever been, it settles. On the other hand, if they have 20 different addresses and, taxes there, schools there, then it may not be possible to get a client to agree to settle a case.
Thank you.
And we try it.
Thank you, Mr. Roy. I'm going to ask one more question, then we'll turn it over to the board members. I just want to ask each individual person, each one of the panelists, if you could just give me one document, one type of document that comes to your mind as to what would be acceptable that the board should be looking into. Just one type.
I just
Just one document. Ask for
problematic.
what's that?
The premise of that question, well, respectfully, I understand that you're
Because
sort of
that was one of the
asking us to
questions.
look at a list.
That was one of the questions. It says, what types of documents should the board be looking at to make these
It
determinations?
sounded like you were talking in the singular as opposed to the plural.
Oh,
So that's why you're getting the answer you
I'm
get.
sorry. Yeah.
Well, I would say even then, I don't know the answer, because when I'm looking at a set of facts, when I'm looking at other documents I've seen, that is going to lead me to other documents that might be relevant. And I just can't sit here today and list the ones that I think are relevant. It could be anything.
Okay. Mr. Bozak, say that.
Did you say it could be any one?
It could be anything that is, as we've all agreed the standard was, is reasonably likely to lead to relevant information.
Okay. I Ms. Pinchich. Did you, if you don't have it,
Well,
if it's not different.
I mean, that's the problem with primary residence versus residential. Primary has a specific need. As Mr. Frost was pointing out, there's an incredibly wide range of documents that somebody who's looking at primary residence would want to see. I mean, mounds. We've delivered thousands of pages of documents to Discovery. That's how it happens. Whereas the residential units, as we said before, we're stipulated to them.
Okay.
We don't even have that issue.
All right, very good. Board members.
But might I just point out, there are even cases where,
Board members.
just one, where we have stipulated to coverage and then had thought about protected occupancy. So, yeah.
We have 10 minutes. You want to use the time in another session? Any board members have any questions?
I'm wondering if you can, so you're having a problem answering it all, but all of you, it sounds like the way law is practiced, that you want to just keep it as open-ended as possible.
You have, I
But
don't
does it, can it have an end to it, or can it just be going on forever, that you keep on discovering and you end up with like cartons in a warehouse?
In some buildings and with some individuals, it goes on a long time because they have complex lives and there's a lot of stuff pointing in different directions, and you wind up, with a mass of stuff and, trying to figure out what matters, and then a judge gets to tell you, this matters, this doesn't. In other cases, it's pretty simple, but if you limit it to, these are the documents that matter, let's say that you decide that there are 4 definitive documents, and where their kids go to school doesn't matter, where they keep their clothes, where they park their car doesn't matter, then you sort of, you really go away from what primary residence is, which is really the question of what is going on here. So for instance, let's say you file your taxes, somewhere upstate because that's where your mail comes in best. And you decide that that's going to be the determinative document. I mean, from my point of view, representing landlords, that would make my life hysterically easy because as soon as I see that document, I'm finished. On the other hand, from a tenant's point of view, if he has a good reason for doing that there, but everything else in his life is at the unit he is claiming, why would you block that? It's sort of, how do you want the system to function? It's based on an issue of need, and if you just say this one document, outside of the Ansonia and the Jagger context is determinative, then you're no longer looking at the basic idea, which is you look at what is going on, and no single factor shall solely be determinative. And if you do this here, it also sets up a problem. Because then, at least one of the things, and I'm thinking off the top of my head because I wasn't ever thinking that that could possibly be a question outside of Ansonia and Jagger, is then, then do I wind up in landlord-tenant court arguing that that there's not a collateral estoppel basis on a primary residence issue because you have decided to interpret primary residence differently than rent stabilization and all of the courts decided. So you said, it's sort of like, one of the things I talk about regularly is, if you will, the rule of unintended consequences, where you make a particular decision for a particular rationale, and you can't figure out all of the things that can happen as a result of it. And if you're lucky, the unintended consequences are minor, and it doesn't matter. And if you're unlucky, something hideous happens as a result. And I'm not just talking from, to a landlord and to a tenant. I'm just saying, you have a theory of a system. And if you're going to change the theory that the system has operated on for 40 years, how are you going to figure out what good, bad is going to happen out of that, other than, as a particular circumscribed view as to what you are doing today and what you think it means?
Thank you, Mr. Brody. All right, I have one question, but I just want to make sure the other board members have.
I have a follow-up to that, because I'm just trying to figure out, so I understand your view and you have similar views, but I'm trying to see where if you're a person, for example, who can turn over a binder of every single bill you've ever had, which might be someone like myself, but someone else that's just not their thing, and they're equally important citizen of New York. What do you say to that? I'm just wondering how to make equity.
What you've been touching on in your questions is the whole issue of the difference between primary residence versus residential occupancy. It's very residential occupancy. You have pictures of the place. There's a kitchen, there's a bathroom, there's a bedroom. They have various documents that show that somebody lived there. You don't have to go through every bank statement, credit card statement, phone bill to see where they were, where they charged something, what they did, ask them questions about it. That's something that can happen later. It's particularly problematic for loft tenants. For a rent-stabilized tenant, it's a legal residential unit when they move in. They know what their obligations are when they move in. When a loft tenant moved in 2008, they had no idea what their obligations were going to be like. And many people were trying to hide their existence there because they were not supposed to be there. It was illegal to be there. Now you're asking them to come up with documents that show that they were. As a matter of fact, in the briefs for the Loft Tenants v. Loft Board case and the Moore Realty case, it's also attached to this packet that came after that. The Loft Board representative of the Court of Appeals is that we are not trying to make people prove their primary residence during the window period. So, because it's impossible to prove, it's difficult for them to have that proof when they were hiding their existence.
Coverage or protection?
And I think there's also a different look between the original loft law and the 2010. And I think it's much more reasonable to talk about tenant fear back in those days as opposed to here. Because what you have in the 2010 law.
As a tenant, I beg to differ on that.
Okay, I am speaking based on what I have seen and what I have learned.
Okay.
I am not pretending to know what goes on in the minds of people that I have not had to deal with. But what I've seen is, in the early loft law, it really sort of became a warfare for a period of time between owners in Soho, who had saw Robert Moses' great plan go down the, go without, and all of a sudden we're looking at these properties where they had been renting out just to have a little bit of bucks coming in at a time, and started thinking in big dollar terms. And they just went after them. And that's Lipkis v. Pecos and any number of the other cases that were dealt with down there. And yeah, there was fear there. But here, you know, a lot of the conversion that has gone on, you know, between the original Loft law, and particularly, you know, from about the late 90s on to the enactment of the Loft law, was everybody knew what was happening. You know, everybody was willing participants in it. You know, when you look at a building like 475 Kent, where you have 100 units, you know, sitting there, you know, and to suggest that those tenants were living in fear, you know, it just doesn't really work. I mean, at one point, that building actually got vacated.
Mr. Brody, Mr. Brody. All right, Mr. Kozak, I have a question for you. You said earlier that your owners asked amounts of documents, you know, during discovery, I suppose, right? So, what rules require production of these documents?
Rules of evidence and discovery. This is, you know, there's a standard set, you know, legal standard set as to what you have to prove in your case. Here we're talking about primary residence, and as I said, to satisfy, if you're going to adopt the event stabilization standard, substantial physical nexus for actual living purposes. The judge, the owner is going to issue a discovery to me and say, here are all the documents that I want. Tenant's attorney is going to say, we object to all of these things that we think are irrelevant or overburdensome because they're not likely to be very relevant here. And there are certain things on there that are relevant. We're not going to object to those things. And then the judge is going to make a determination. Well, that's what's relevant and that's what's not relevant. When you're talking about primary residence, there is no way to limit that. Everything is relevant. So that's the rule. The judge will simply say, you have to turn all of those things over because it's either relevant or may lead to relevant information. And I've been through many discovery periods with Mr. Brody's office and other attorneys where that was the standard that was applied, and there were very little limitations, if anything, placed upon the discovery. And then, frankly, then you end up getting to trial, right? You send a discovery demand to the tenants, and they say, my God, you want me to produce all of this stuff, every single statement for every single account that I've had for the last 7 years. That is an enormous burden. We're talking about a truckload of documents that get turned over. And then what happens is, all that good stuff gets turned over, and at the trial, the first line of questioning is on the discovery demand. Did you produce every bank statement? Do you have any other bank statements? You don't have any other, you have other bank statements? Did you produce those documents? No, I didn't produce them because I forgot I had that account. I closed it years ago. Well, you were required to produce it. Now we get into a fight at the trial about not the issue at hand, whether or not they're occupying for residential purposes, but whether or not they comply with the discovery demand. I had a 2-day trial with Mr. Frosch. We didn't even get to any of the issues regarding residential occupancy. The trial was focused exclusively on the discovery demands and the extent to which my client had responded to it. So, it's, you know, to me, it creates those kinds of burdens and those kinds of problems when you're litigating this case.
Yeah, please.
Sure, Mr. Cross.
So,
He named you.
yeah. This was a trial where the first witness that Mr. Kozak put on disclosed in direct examination that he had a house that he owned upstate. My discovery demand asked for deeds to any houses that are owned, basis renting properties on the subject premises that are obviously relevant to the issue of occupancy in residence and primary residence, and was never told that there was any property whatsoever in the normal course of discovery, and then come to find out in the middle of trial that there's relevant documentation that wasn't produced. So yes, this was a particularly anomalous situation, and we ended up having to do a little bit more of an examination about what documents existed, were demanded, were never mentioned as existing, and then all of a sudden in the middle of the trial they come to the fore.
Okay.
I will also clarify on the general issue. The problem we have here is that a 2010 law that people could have applied for in 2010 and 11, and at that point would have only looked back to less than a year's worth of documents, has now gone on for 8 years with those same dates never changing. And now, I don't think anyone really expected to have 8 years worth of documents be relevant to the issues at hand. That's really the problem here. And it's not the owner who's trying to ask for an overburdensome number of documents for some bad faith reason. It's because that's the relevant period, like it or not. And the owners didn't choose that, and the tenants didn't choose that.
Just another reason why primary residence is a mistake for this kind of procedure. There's no way around this incredible amount of documentation. If you're a rent stabilized tenant, it's key to the notice. If you were a loft tenant prior to this discussion that the board is having based on the board's eviction regs, it was key to the service of the 30-day notice. So a year or two back from the date of the 30-day notice, that's a very discrete period of time. Now we're talking about documentation from 2008 to the present. It's just impossible.
If I may. Mr. Rush, before you go, Mr. Rush, your position is that the law is because the law requires it, not necessarily the law.
The law has dates built into it, and those are the relevant periods of time, and they're a long period of time.
And what about reason? Reason.
Reason?
Yeah, like reasoning. Like he says 1 or 2 years. You said the law says, what did the law say 20 years back?
There are many different types of litigations that do look to periods that are 20, 30, 40 years. There are grandfathering cases for the Board of Standards and Appeals that look to documentation, photographs, aerial photographs, all sorts of different complicated evidence going back to 1961. So this is not even the most onerous type of case.
Mr. Rhodes, you can close this out in 10 seconds.
Okay. 10, not possible, but short story. If the law is amended to provide a new window period and to provide a new coverage date, then the problem of having to go back to 2010 is pretty much obviated for the new cases that will be brought. But one of the things that is necessary, is that, tenants who are aware of this, the faster they get their applications in, the less that they will have to deal with. And another point, it's sort of like, Mr. Petrucci knows this, now that there is no sunset date for the law, we can expect, well, not Mr. Petrucci and me so much, that 20 years from now, you will be getting that one Lager building every year where, for whatever reason, they're only showing up then, and, yes, they won't have to deal with a significant amount of going back documentation.
Thank you.
But that's the way the system is set up.
Thank you. So the system is broke. Is that
there are many issues with what this law is and what this law requires, and I would think it would be fair to say that there is a certain level on which we all struggle to make what we are doing make sense and to push forward the purpose of the law.
Thank you. I've dominated this whole thing. I don't know if a board member can go on to the next question if you have.
So, I'm not sure exactly what my question is, but I was thinking as you were talking that there's a certain point at which, in some ways, you're trying to prove a negative. So, say I'm a savvy tenant, Sam Smith Metalworks, and I'm going to register. My lease is with that's the lease, that's the rent. I have a commercial electric bill, and then I have a PO box where my mom sends my birthday cards. And there is literally no proof that I've ever lived in this space, except, as you say, that I'm living in this space. So Discovery could call for documents till the cows come home, and there are no documents.
Yes, and there are cases like that. And I remember, at least with one of the tenancies that we stipped out in 83 Canal Street, the particular tenant had absolutely no documentation whatsoever. His parents lived uptown, and what little bit of documentation he had there. So, we went about, enough through a hearing that we were satisfied that on credibility grounds, this tenant had lived there the entire window period. Because, one of his parents came in and testified, a couple of the other tenants testified. And, it was just very obvious in which direction it was all going. And, if you go back through the case law, and I got to admit, sitting here and having that question, I don't remember the cases particularly, there were tenants who had no documents to support a coverage claim, But they brought in people, they said, this is what I'm doing, this is the only place that I've ever lived, et cetera, et cetera, et cetera. They brought in a couple of people, they testified, and, the decision is, the issue of coverage then becomes an issue of what the credibility of the person involved is. What is the credibility of the witnesses? And, that's something, as litigators, we deal with, in that and other contexts in court. And there are going to be people who just, for whatever reason, don't have papers, but, where to, there has to be, if you're going to have a standard that says, going back to, what are the papers you have to have, unfortunately, ultimately, if you have papers, they need to come out to show what's going on. But if you don't have any papers, you can't produce anything, and the court's got to hear you, and the law court has got to make a decision.
Thank you, Mr. Brody. All right, so we have to get to the next question, question number 4. Mr. Brody, you're going to actually begin this question. So the question is to all the members, and after Mr. Brody, then Mr. Frosch, Mr. Petrucci, then Mr. Kozak would answer. Should only the prime lessee be protected? And does it matter if the lease is in place? And if we decide to protect others, regardless of the lease issue, who should be protected?
Let me break that down.
You have 2 minutes.
Never enough. Let me break it down into a couple of pieces. One of the early cases out of landlord-tenant court in the 80s, when they were dealing with it more actively, before the law court really got set up, was a case called Duncan v. Dworkin, or maybe it's Dworkin v. Duncan. Thank you. Where we've mentioned it enough. Because one of the issues, and it's sort of out there, is is it an illusory tenancy situation where this particular tenant, either with or without connivance of the landlord, is just holding on to a premises for personal profit. And there's a lot of case law that deals with that. So that's one issue you get to play with. Who is the real, and the law talks about an occupant rather than a tenant as being protected. So you got to look at that.
Should only the prime lessee be protected?
If there is a person, and the answer there is no. And the reason that the answer there is no, unfortunately for me, is, and more, it's more so, in Brooklyn, where you would have people renting 10,000 square feet, whacking it up into 10 units, and still having the prime lease, and maybe living there and maybe
Does it
not.
matter if there's a lease in place?
I think the first place you have to look is the lease.
Okay,
I think you also wind up with taking issues ultimately, and, I haven't litigated that issue, but I think it starts being there at a certain point in the
And who are the
discussion.
other people that we should protect if there is regardless of the lease?
I think that, where there is a prime lessee who is in occupancy as a primary tenant, that is the answer. I think, his children and his spouse come along by way of succession, and I think that anybody living with him, unless they can show a basis for a succession claim, doesn't get to stay. I think with occupants and protected. I think that with people who are occupants of a tenant, and you have these fights between primes and subs, I forget the name of the case. Mr. Petrucci mentions it, if it turns over, I'll see it,
Matter of small coverage.
yeah, thank you. You get to look at, who ought to be protected and under what circumstances. And if the prime tenant isn't the person, then you look at the other 2 people, and the owner and the occupant, and you say, why does each one have an issue? And that's the way it is interpreted correctly.
Smoke.
The smoking case that says it's tab G.
And there's both your decision and there's also the reported decision out of the mix.
Mr. Frosch, if you could just...
Sure, yeah.
2 minutes.
Yeah, so there was a good conversation that the law board had a few months ago where Mr. Carver was talking about the serious constitutional concern and ethical concern of erasing the right that a prime lessee has to exclude other people whenever they wish. And I've circulated to the members a case or 2 dealing with just an exemplary set of facts on this, where there's a couple and they end up becoming co-tenants, co-protected occupants of a unit, and then they have a domestic dispute that gets pretty serious. And she obtains a protective order against against him. He has to go for that temporary period of protective order, and then she's unable to make 100% of the rent. And they're nevertheless jointly and severally liable for 100% of the rent for the unit. So the concern here is if we say there's no significance to someone being on a lease versus being there pursuant to the license and the subtenancy or roommate status given to them by that person on the lease, you are creating all sorts of potential conflicts that are completely unintended. And I don't think a lot of people are anticipating that that would be the consequence. So if the law were to work the way that it did in 2010, take that snapshot in 2010 of whoever is in occupancy and say they're all equally protected occupants, you're erasing whatever preferences the prime tenants have to say, actually, there may come a time where I don't want this person living with me forever.
Thank you. Thank you, Mr. Brock. Mr. Chich.
Well, we wrestled with this back in '83. And that's the genesis of, even though there's been a lot of talk about D4 in your recent, the subletting regs in your recent order, and there have been claims made about what it meant, that regulation was basically written by LMLT. And that was written because the landlords didn't really care. They were having a great time because we were fighting among ourselves about the subprime issue. And that regulation was only intended to deal with a prime lessee being able to recover space that was occupied by somebody else. That was the only intent of that regulation. And I'm surprised to see people talk about it in your orders that it means something else. But it was never meant to be that way. It was something that the tenants, after a lot of fighting among ourselves, I remember very clearly because we had different people on different sides, and subtenants and prime tenants who had different views of this. And the law board just basically stayed above the fray, or the executive director of the council stayed above the fray. The landlords were laughing at us, and we were just fighting it out with ourselves. And that's the regulation that we came up with. And I still feel that that's a really good compromise. It does present other problems, but other choices would present greater problems if I. So I'm comfortable with the regulation as it stands now in terms of deciding who is protected. Meaning that if you're in place prior to the effective date of the law, you obtain protected occupancy status. If there's a prime tenant that wants to recover that space, then they have to exercise that right at a court of competent jurisdiction, showing that it's their primary residence. That's the standard that we came up with then, and I still subscribe to that.
Thank you, Mr. Kozak. You get to.
Yeah, okay. I wasn't around in the Loft law in 1982 when the law was enacted, and but my understanding is that the reason that the Loft law used this term occupant rather than tenant was because the relationships between the occupants was not so clearly defined prior to when the law was enacted. And that there was supposed to be a broader idea about who this was intended to protect, because you had commercial entities on loft leases, and you had, various people living together in loft spaces. And so if you were there before the date of the enactment, the existence of a lease was sort of irrelevant. And the case law and the law board has said that you disregard the lease. And so you're talking about the way the law board regulations are currently set up is you have people who were there before the date of enactment of the law, and those people came in afterwards. And so there's a broader standard applied for the people who came in before, and there's a more strict standard as to what people who came in afterwards. And that has to do, the standard for afterwards has to do with their relationship to the landlord, whereas prior to that it doesn't. It has to do with the relationship to the space itself. And so if you came in afterwards and there's a prime lease holder in place, the rules say you have to also, in order to get protected status, you also have to have a relationship with the landlord. And the law board's precedent on this have talked about that consent. And the consent talks about payment of rent, direct dealings with the landlord. So the lease itself doesn't clearly define who it is that's running the space when you've got other people who are in a direct relationship with the landlord and dealing with that space. And so the existence of a lease is sort of irrelevant to all of this. The question is, were you, as of the day of the enactment of the law, were you there? Afterwards, what was your relationship with the landlord? Seems pretty straightforward to me, and that's the way it's always been dealt with at the law board, and so that's how we view it.
Thank you, Mr. Kozak. Board members, questions?
All right, so we're talking about a change that's on the table. So just to be clear, the rule that's on the books presently, in essence, in the absence of any lessee, anyone in occupancy could, if they meet other standards, qualify. In the presence of a lease, if a lease is presently, if the prime lessee is eligible, that eligibility acts to the exclusion of all others. Is that right?
Yes, and I would also just clarify that the lease, in terms of the definition of a prime lessee, it includes whether or not the lease is currently in effect.
Okay.
So it lasts past the expiration of the lease.
Okay. So the proposal that you've made is, in essence, to revoke the superior status of the lessee. Is that right? Just so I'm clear.
That is a concept we're exploring.
Okay, but
Yes,
that's the draft that's on the table, and that's why we have these guests here today.
correct.
Okay. So I guess my question to all of the panelists first is there support in the statute itself, in Article 7B, to give equal status to occupants, whether or not the occupant is a lessee?
Wait, can you, sorry, hi Robert. Can you qualify when you're saying present? We've been talking about it a couple times today where it's like, is it the date, June 10th, 2010? Is it 8 years later? What do you mean present?
I want to assume that those people would be qualified otherwise, regardless of, in other words,
Is the prime lessee present? Where is he or she present? And at what point?
In the unit and claiming protection.
at the right time. Yeah. So in other words, I want to put to the side all other issues of qualification and just focus on the status of the occupant as to whether or not they're an occupant in the presence of a lessee or not in the presence of a lessee. So the question is somewhat convoluted, but is there statutory support for the change that's being proposed? In other words, to put all occupants on an equal footing, whether or not the occupant is a lessee. In other words, where in the statute is there support for the change?
The statute refers to occupant, doesn't refer to tenant.
Well, the word tenant appears in places in the statute, and even where the word occupant appears, that the same section, in fact, this one that you cited, 286, 2I, also talks about a rent-paying relationship between the occupants and the landlord.
I can address the question.
Yeah, well, please.
The term protected occupant comes out as a sort of rephrasing of the phrase residential occupant qualified for protection.
Right.
And there is no definition of that phrase in the law anywhere. But it is used, and that phrase is used in a couple of important places. 286, 2I is in one place.
Yeah.
And the other two important places that it's used is in 286.6 and in 286.12, which speak to the rights of somebody to sell their fixtures and improvements and their rights to sell their rights in the unit. And those are critical for this discussion, because if you're talking about who has the rights to the unit, it's the person who has the right to sell their fixtures or improvements or to sell their rights in the unit. And in those two places, it uses the word occupant. It does not use the word tenant. And so the law board has been given, I think by virtue of the failure of the legislature to define that term, the discretion to determine what it means in a broader sense. And so that's where the authority comes from. By virtue of the lack of that definition, the law board has been handed over the job of figuring out what that means and who is entitled to that protection.
Right, but of course, that's one way of looking at it. I mean, the very title of that section uses the word tenant, right? Not occupant. You know, I don't know that it's the statutory argument is going to be strong either way. Let me ask the attorneys for the owners about statutory support either for the current rule or the proposed change.
Sure. Well, I think that at least currently, the law is pretty solidified since 2014 that a prime tenant blocks the claim of a roommate for protected occupancy. And yeah, I mean, this was also discussed, I think, by Mr. Carver in a few prior meetings. And I would disagree with Mr. Kozak that the use of the word occupant alone is used in any of those key provisions. It's always occupant qualified for protection under Article 7C, and that's a question. What allows someone to become qualified as the protected occupant? And 286 tenant protection, sub 1 refers to violations as a basis of a tenant's lease or rental agreement as a basis for eviction of a protected occupant. And in 2I refers to the requirement to maintain as a primary residence and says that the tenant entitled to the occupant entitled to protection shall pay the same rent, including escalation specified in their lease or rental agreement. And then talks about as a secondary actual scenario where there is no lease or rental agreement, what happens. So it's already indicating that there's a primacy to when there is a person with a lease versus when there may be a person where there's no lease. And to what Mr. Kozak mentioned about the right to sell improvements and the right to sell rights, that is why, in addition to the right to exclude that a prime lessee may have, it's crucial to understand the possible consequences of wiping out that hierarchy and saying, now everyone who happens to be there, whether they were staying temporarily, whether they were just visiting, whether it was only intended to be a year that someone was going to stay and then their sublease was up, that all of those people now have a co-equal protected occupancy right, and no one of them can unilaterally sell improvements or sell rights. It's a serious consequence amongst tenants, and it shouldn't be taken lightly in deciding to just wipe away the expectations that people in the unit that are on the lease have with respect to the people there.
And going a step further, you know, while certainly there is a bit of room to move under the law, and notwithstanding that the law board has pretty much stated what its opinion is in the context in terms of the case that it's developed, you need to remember that, again, law exists in a historical construct. And a lot of what we are talking about is how do you deal with traditional concepts of privity? You know, is it fair, you know, to tell to a landlord, you know, you made a lease, you made a rental agreement with this person, but we're going to put, you know, we're going to make you keep this person. There are circumstances in which it's a rational thing to do, such as the illusory tenancy type of situations, and there are places where it may not be so rational. And where you wind up ultimately bumping up against in the constitutional construct is you have to concern yourself that what you do winds up being challenged as a taking. And, you know, the last time there was a real successful attack on if you will, a rent regulation idea that was a taking is really going back to the 80s with Seawall Associates, where laws concerning what you can do with rent-stabilized SROs have continued, and with a certain amount of strenuousness. But there, what the legislature originally said was, in addition to everything else that continues to exist today, you need to fix up all those units and rent them out. And there, the court says something to the effect of, while you can tell them how they can deregulate, while you can tell them how they can maintain, and these code sections that require there be proof of no harassment, at the point that you tell somebody that they have got to rent out an apartment and that they have got to fix it out and rent it out, you have stepped over the line. So, while it doesn't have a direct correlation to what you were talking about today, it's something that, as you make that determination, you need to think about, what under traditional privity, traditional contract law gives you the ability to do what you are doing.
As a practical matter, if every occupant is equal to the lessee, what happens if you've got one bedroom and 9 occupants? In other words, I imagine there are going to be practical issues where the space can't handle the number of occupants practically, and secondly, you probably run up against some sort of statutory limits on how many people can actually be in a single unit.
The argument actually winds up coming in issues, depending on the relationship of the people, as to whether what has been created constitutes an SRO. And if it constitutes an SRO, that implicates one way, and it also gives you issues in terms of legalization. If also, assume, the other question is, pops up in legalization. I've got a unit that has 5 roommates, let's say, but because of light and air constraints, there's only going to be 1 bedroom. What do you do about that? Who is controlling? Where it has shown up is mainly, they describe landlords standing back and laughing at it, but there are serious implications. And while the tenants and the subtenants and the co-occupants fight it out amongst themselves, eventually it has an implication as to how the unit continues, how the people in the unit continue, and your responsibility in the first instance is not just to look at who you're going to give protected occupancy to, but how that is going to play out in terms of the use of the unit, the legalization of the unit, and what goes on amongst these people.
Director Balsam, is it okay for me to talk about 1315 Thames now? I think we're in the clear, right? Sorry to...
Yes.
I think we're in the clear. So I did circulate the most substantive on the merits law court order on that case. And that was really, I think, the most insightful factor in terms of when this problem is pretty different. And this was a case where a prior owner had stipulated that 7 people were claiming protected occupancy in a single unit with a lack of windows. There was really only 2 windows in the back and a lot line in the front. Stipulated they all be protected. And this ran up against, in the law court's view and in the oath judge's view, the limit on how many people that are not a family can be the occupant of a multiple dwelling unit. And without a finding that all of these people were a family, it was not possible to permit them all to be protected occupants of this unit, particularly given how difficult it would be to legalize where each of those people can have bedrooms. And this went up and ultimately was reversed on the grounds that because the owner had stipulated that they were protected, all of the necessary criteria underneath what that meant were implicitly stipulated to. And we can agree or disagree about that. But the ultimate basis for why the law court had a problem with this is still a concern. And outside of that limited factual scenario where an owner, prior owner in this case, stipulated that everyone's protected at the end of the story, it's still a problem that's going to come up in the law court that doesn't have a clean resolution. And so part of the issue here is, what is the limit to the number of protected occupants that can qualify? Considering not only that protected occupants can have a spouse and children in occupancy, but there's a certain number of roommates that are limited by applicable law that may also be unrelated and permitted to stay with them. So you may end up with 7 protected occupants, each of whom can have their spouse, children, dependent adult family members perhaps, and an unrelated roommate, and that unrelated roommate's spouse, children, and other dependent adult family members. So how can you possibly provide for legal, healthy, and safe accommodations for that many people? It's a concern that hasn't really been addressed yet.
I'm curious, do we have the same concern for a grant lessee, very big family?
It could be a problem, but I would imagine that if that was the way the unit was being used and it was functioning in a way that was reasonably healthy, where maybe certain children were in the same bedroom during the window period of the effective date, that makes it perhaps a little bit less difficult, although without a scarcity of light and air, it may be incredibly difficult, if not impossible.
If you apply, it's a family of 9 people to the units in 13, 15, 10, they're 100-foot long units. The building is built full to the lot line, and there's one small that you can enlarge the window in the front, but short of moving the back wall in 5 feet, which will still only get you a limited quantity of light and air, you have no real ability to build bedrooms.
Thank you. All right, board members, we have one more question.
Can I ask one follow-up? So basically we're talking about when a situation when we're creating an IMD, right, which is an intra-multiple dwelling, but the multiple dwelling does not then conform to the multiple dwelling law?
No, it has to, with legalization, you have to be able, with the exception of Soho, you have to be able to get a certificate of occupancy pursuant to MDL 302. Article 7B, gives you certain lesser restrictions that would ordinarily apply. And the law board's regulations, provide it out to the effect that if a unit cannot be legalized, the law board can do what it thinks is necessary, including decoverage of it. You have old case law that says that Nerco Associates, Little Orphan Annie, and a few others, and under with respect to one of our other buildings, the landlord had ground floor basement duplexes and had registered the entire units because that's what he wanted to do. And as a result of the narrative conference, the 2 architects got sent over to the Department of Buildings in Brooklyn, and the end result was that the law board issued the executive director issued an order decovering, if you will, the basement portions of the units. So if it's impossible, to legalize it, that's one out. But if the answer is, you've got 9, your family with 9 children, and you've got a unit that's so constructed that you can only have 1 bedroom, then you have to make a decision as to what you are going to do with your life in that circumstance. Because if we have to legalize it, you're going to have a unit that has 1 bedroom, and then you have decisions as to how you are going to focus and function under that circumstance.
Right, but Robert's bringing this up. I mean, so that's kind of what you're getting at, right? Like, so there's certain circumstances where pursuing of one aspect of protection is going to negate another aspect of protection?
If I may, a more accurate way of stating it is, it's an, protected status and coverage would have coincided. And at the end, you may not want, the end result could be, if it is not legalizable, that the unit becomes decovered. At the other end, the unit may remain covered, but you have a living situation that is not a viable living situation for you. At which point, do you, say to the landlord, please buy me out so I have money to go live somewhere else? Or do you just figure out some other way of organizing your 9 children?
And then we have the problem of if you have everyone protected and they don't get along, what happens then? Yeah. And if there are...
I mean, that's just like a family
Mr.
that...
Kozak, I think Mr. Kozak wants to answer.
Oh, okay.
I would like to respond. I mean, we've heard a lot from the on this side of the table about this issue.
Because you're not speaking.
I find it sort of odd that one isolated and rather extreme and still unresolved case vis-a-vis legalization ought to result somehow in the nullification of the rights of thousands, potentially thousands of other people who would otherwise have rights under the law.
Such a mistake.
It's a misstatement.
Yes,
Mr. Brody
it's
said.
an absolute
Let me
mistake.
So,
answer.
that's fine. Well, this is the case that they've cited. It is a rather extreme one, and we have no information about how the legalization issues are going to be dealt with in that particular situation. But it doesn't really matter, because those people are the protected occupants of the unit, and it's up to them to decide how they're going to organize themselves in the unit and deal with these issues. If it was, as you raised, Mr. Hilton, a family with 9 children, they would do the very same thing. People have to organize themselves in these spaces and figure out how they're going to be legalized. That's the purpose of the law is to figure out how these spaces are going to be legalized, given all of these different possible scenarios of who's in occupancy and how many bedrooms and how do we deal with those light and air issues and whatnot. So I don't think it's fair to rely on this particular situation and say, well, that's something that should be cited as a basis for saying, well, all these other people who aren't in that situation should get their rights.
And may I say also that the same issues that are in lofts as far as goes with occupancy into loft dwellings, the same is in the same 1-2 family homes in the city of New York. I mean, we have the same rules. It's different. Anyway,
I don't agree, Ronaldo.
You don't agree?
No, because
There are rules. I'm not saying it's the same exact.
No, here you're wiping out the value of the leaseholder. That's a very big difference. So, with the stroke of
No,
a
I wasn't
pen,
talking about that. I was referring to the
To the building code.
yeah, but all these things are operating in tandem right now. Yeah.
All right. I have one more question to go, and it seems that the board will not have a chance today to do any.
I was just going to follow up quick if I could, because you cut me off when he was talking and he keeps talking. So I was just going to say it's similar to like a divorce of a couple. Like if roommates don't get along, they resolve it elsewhere, not here in this on the law board.
I guess
For your example.
my question.
But I'd rather hear from the professionals here that are guests.
Yeah, that's the
too much
question.
of-
How to resolve it? That's the question.
I know, but you're also getting into rulemaking, and we're not doing that right now.
So
I'm not quite understanding the purpose of.
You're like leading the discussion, and you're not the lead. Ronaldo is the lead.
Okay, so are you asking a question though of the?
I was just following up because he gave this scenario, he started going into scenarios of that we're making a decision that's gonna not be upheld because how would all these roommates, if they don't get along, how would we resolve it? I don't think we need to resolve it. That's held in another court like divorce.
I know that's the consequence of the rule change on the table, which is why I'm bringing it up. And I'm asking the panelists how that problem could get resolved, which is an important answer for all of us to hear.
Mr. Carver, I think what you're saying is that that's not an issue for this board. It would not be resolved here, correct? That issue.
I at least have an answer to that. It affects legalization. So the ability to get through a narrative conference is directly related to the difficulty in coming up with a solution for legalizing a unit. If you have one protected occupant in a unit and they want one bedroom, the title's one bedroom, it's easier to get through legalization typically than if you have 7 people who claim they are entitled to a bedroom and are filing oppositions and applications for interference and slowing the process down based on the claim that they all want bedrooms when it may not be easy or possible to get that.
How did they get to that point? How did they get to that point where you have multiple people?
Because the decision of whether to provide protection to everyone, regardless of whether they're on a lease or they're a roommate or a temporary occupant, directly affects how many people are entitled to co-equal protected occupancy rights and perhaps bedrooms and other rights in how the unit is
So the
given.
occupancy was okay up to the point where people applied for protection.
I'm sorry, I couldn't.
So the occupancy was fine up to the point where the occupants applied for protection.
Well, a lot of these units, I think maybe what I'm understanding your question is it was fine before it got under the law board's jurisdiction, so sort of what's the disconnect? And I think the disconnect is that people are living in conditions that are not compliant. And now they have to be brought into compliance with health and safety requirements. It's a serious concern, and sometimes it's very difficult to increase the number of people who have the right to remain in occupancy, or protected occupancy.
And in terms of, you know, if 5 people have protected occupancy rights and they have a disagreement amongst themselves, I think that may be an answer that the tenants' attorneys probably deal with more than we deal with. I mean, the one case that I thought of and that I've seen in a couple of places is a case called Stellwig v. Welch, where in a building that Mr. Petrucci and I think, 2000, it was a 1982 building that nobody had problems with anybody. It didn't come into registration until somewhere in the early 2000s. There was a couple named Stellwig and Welch who I don't remember whether or not they were married, but they were living as though at least. And they had a serious falling out. And one of the two of them brought an action in partition, and so obviously we got named. So the one thing that we know from the end of that action is that, as with every other form of rent-regulated unit, there is no such thing as an action in partition. So what they, how they resolved it amongst themselves, since the building eventually sold before they resolved whatever it was they were resolving, I don't know the answer to.
They reconciled. They were married couple.
Okay, good answer, decent answer.
Happy
Yeah, but if you have 5 people and all of a sudden, they get to a point of real dispute, I don't know the answer to that if they're all protected occupants.
Or do we have another question?
Yes, we have another question, and this is the final question. How did Mr. Kozak, you're going to get this one. How did the process function in the past, and what changed?
I think Mr. Petrucci and Mr. Brody are going to have a little more experience to talk about this. But when
You say you're the younger one?
Bob and I were the only ones who were actually born at the beginning of all of this.
Not entirely, but I'll say this. I began practicing in this area of law after I graduated law school. And some people know this about me, that I'm a former Loftian myself, grew up in a couple different lofts. Came right into practice and worked for my partner, now deceased Jeffrey Wing, and very quickly got sort of indoctrinated into this world and thrown into these cases. And from the beginning, the enactment of 2010, when I was there, and all of those early cases that were first coming before the law board and ran over and litigated a lot of those early cases, up until 2014 when everything changed with Manor Pack first, with Manor Belkey, and then the Mariner Smith case. But that was the shift that happened. So in that period of time, I can tell you that when I was at Oath litigating these cases, there wasn't a single attorney on either side of the table, landlord or tenant, who believed that you had proved that the unit was your primary residence or get protected status. There wasn't one. Nobody made that argument when the subject came up at Oath. Everybody was in agreement. That's not something you have to do. Something happened in 2014 with Manor Pack. I don't think the landlord attorney in that case argued that it had to be your primary residence. I think the law board somehow did it on its own. Sua sponte, decided, well, this now is going to become a thing. It changed in 2014. And then since then, it's been just sort of adopted over and over and over again for some reason. But prior to that point in time, all you had to do was show that you residentially occupied the units. That's it. So it was some documents that show you residentially occupied the unit supported by some testimonies to that effect. That got you there.
So none of the attorneys here on the board were part of that case? Madam? Thank you. Mr.
That's accurate.
Okay.
I mean, basically what you had to do is, as I said at the very, very beginning, there was, what's a covered unit? There were two steps. Did that person come in before the effective date of law or after the effective date of law? If they came in before the effective date of law, they were automatically protected out. They didn't have to show anything else. No primary residence, no nothing. They came in after the law, and they had to show that the landlord accepted them as a tenant, either by lease or rent or something like that. No primary residence. However, you will not find a single case prior to 2014 that looked at primary residence in the context of protected occupancy, unless it had to do with before, in very limited posture of prime tenant recovering a unit from a subtenant. Other than that, there was never any discussion of primary residence in terms of protected occupancy.
Mr. Frosch, thank you.
So, as a youngin who came in, pretty much right before the matter of fact was decided, and this has been the universe I've been practicing the law in, I think it's ultra-virus not to have a primary residence requirement. It is also absurd because we would end up fighting two litigations, and the tenant would do the same litigation against the owner in a separate court while simultaneously fighting about coverage here. It doesn't actually provide any more efficient resolution of the issue. It's just not worth discussing dealing with taking this issue and exporting it to a different court instead of dealing with it all in one proceeding here. Now, I will also point out, the first law court order, as I mentioned, that enshrined the new primary residence requirement is Mariner Smith. And what were the facts of Mariner Smith? Mariner Smith had the lease for the unit, and she claimed that every so often she had a bedroom in the front that she would kick one of her subtenants out, and she'd sleep in as a pied-a-terre when she wanted to live and or sleep in Manhattan. But most of her time was spent living in her house with her husband on the coast in Long Island. All of her documentation showed that she was in Long Island, and she was essentially a mini landlord renting out her unit to a bunch of younger, probably less well-off tenants, exploiting them and overcharging them. And then all of a sudden, when she realized she might have a claim, she changed all of her documents, she changed her board registration back to the unit, she refiled and amended her tax returns, and suddenly she claims, actually, I'm primarily residing in my unit, and it's always been my primary residence.
That's false.
And
I'm sorry. I'm going to interrupt.
Yes, no, don't interrupt. I'll come back to you. Go ahead.
I wasn't involved in that case, but I'm paraphrasing the decision that the law court issued, and you're perfectly welcome to take a look at that law court order for perhaps a more precise articulation of those facts. But the substance here was that Mariner Smith was not living in this unit. She was a mini landlord in this unit, and then tried to come in and fix that at the last second in order to get protection. Now the question here is that the correct answer? Is that the equitable answer? Should a person who doesn't actually use the premises of their primary residence be entitled to protection in a housing emergency, or should only the people who are able to show that it's their home be entitled to that protection?
Thank you, Mr. Frosch. Mr. Broder.
The law is evolutionary.
Okay. What?
The law is evolutionary. What we started out with and what we knew in 1982 when we started doing this is much different than what we know today and how we practice today. And it's both from a landlord's and a tenant's point of view. You know, switching gears a little bit, I mean, you know, the are you in compliance question developed over time from the tenant's perspective as to what was and was not. So, you know, the initial view, you know, starts developing over time. Likewise, you know, where we were all litigating back under the original law was looking at sort of primary residence and coverage as being somewhat synonymous terms in terms of the discussion. And so, you know, hopefully we all get smarter over time, but sometimes the problem with getting smarter over time is you see more issues that you need to get involved with. I don't remember when the first time I got involved with discussions of primary residence, qua primary residence as opposed to coverage were. I know that I have a vague recollection of having done it with Bob in 206 Bowery, which was one of the earlier cases on, and, you know, he was to be, and he was successful at that case and I was not. But as I started thinking about it and I started developing it, we started litigating it. And a prime example, and I'm not going to name a building or anything, is Bob and I did an incompatible use case. And to be nice about it, I would say we were both fairly ignorant about the science and everything that went along with it when we started the case. And we developed both the science, the arguments, and the fight during the course of the case. The reason that you talk to us about this is because, our insights in how we go about this is useful. And it also talks about things that you need to be thinking about in terms of how you approach it. And the issue as to, how did we function in the past, it has a certain level of instruction. The same as, if you will, looking at the Supreme Court case law, the world before Roe v. Wade has an instruction. But then you want to say, what has happened since this particular decision? How have we developed since? How have we thought since? And, given our experience over time, what matters in terms of saying how the laws should act, how it should develop further, and what is our function in it, and what is your function in it? So the issue of, how many protected occupants should there be in a unit? Does the lease matter? Does primary residence matter? It's not just a matter of how difficult does it make the litigation. It's a question of how does it go to what the purpose of the law is, which is to determine whether or not these buildings should be subject to rent regulation, and the people living inside of them should be protected occupants of some species. And if we enact Rule X, where do we go from there? If we act Rule Y, what are the intentional and what are the unintentional consequences? And yes, we have very firm views of this. And, to look at it as being, landlords are anti-tenant in this, and tenants are anti-landlord in this, is sort of to miss the point. On a certain level, whether we like it or not, we're all stuck in this together. Right. And what are the answers that move us forward in the best manner?
That's right. I appreciate it. Thank you, Mr. Brody. Mr. Kozak, I'm just going to allow you to rebut. I guess you have some clarification.
Just briefly on the Mariner Smith case, I represented the tenant in that case. That was a case that came after a matter of fact. The law court had already implemented a primary residence standard. And Ms. Mariner Smith, at the trial in that case, testified that the unit was not her primary residence. And that is stated right in the law court's order. She did testify, Mr. Bobick, I was there. She testified it was not her primary residence. That's a fact. You can look at the trial transcript. She admitted it was not her primary residence. I take exception with the use of that case. Again, the same way I take exception with the use of 13, 15 claims, extreme examples used in ways to effectually, to undermine the rights of other people. Not everybody is Ms. Mariner Smith. You have a lot of other people who are out there living in units, they don't have their documents to show that this is their primary residence. Should they be subject to a primary residence burden? They are actually occupying the unit. It is their primary residence, but should they be subject to that burden? They're citing those types of extreme examples in an effort to impact all of the other people who are not in those positions. I think that that's totally inappropriate.
Okay, thank you, Mr. Cohen. At this point, I'm going to have the board members just wrap it up with questioning for the next, they say, 6 minutes.
This whole question of how did the process function in the past and what's changed. One of the cases that came before the board where the order that was ultimately adopted kind of articulated what happened is a case at 79 Lorimer Street where the oath judge found for much broader coverage in terms of the number of protected occupants than did the board ultimately decide. And the first proposed order in the summer of 2017 was not adopted by the board. It could not gain a majority. The board rewrote its opinion. In its analysis, there's one paragraph, brief paragraph I want to read, and then I'll get to my question. After the 2010 amendment, The Loft Board made changes in its administrative processes and in its quasi-judicial functions because the statutory deadline for coverage and registration applications did not apply to determinations for protected occupants. To avoid restricting the rights of occupants seeking protection, the Loft Board staff administratively created a separate protected occupant claim by adding it to the general application form, while the claim for coverage remained as a separate application. In addition, the board began to include more detailed analyses of the protected occupancy issue in its decisions. The board adopted a more disciplined approach, adhering to the plain language of 29 RCNY 209B. This change in the board's approach was the catalyst for a divide between interpretations of 209B by the Loft Board and Oakland. So, Mr. Petrucci, you've been a practitioner for a long time. Did you attend the hearing when the board made these changes?
No, the first time I was aware of these changes, the order was adopted.
Were you notified of a hearing?
No, I was not.
Do you know if a hearing was held?
I have no idea.
Do you know if there's any discussion by the board for that administrative change?
Not that I know of. Okay. I've had plenty of discussion with both parties and nobody and other attorneys, but nobody.
All right, thank you.
Where was that?
Can anyone else respond to
Yes.
that question? Yeah, I think this is...
By the way, we litigated that case with Mr. Kozak. Mr. Frosch was trial counsel on that and did most of the writing on it.
Well, I would just add that I don't really think Mr. Delaney's question got to the merits of that case. I think he was just reading that summary from the Loft Board order. But my understanding of what that is describing is such a ministerial change. It is, the history has always been, I think it's beyond dispute, that coverage and protected occupancy were brought in the same application. It was called a coverage application. And then when the time period expired for filing coverage applications, the view the Loft Board had was, well, that doesn't put a time limit on filing protected occupancy applications. And prior to the existence of the sunset period for filing, which was something that came about in the 2010 law, it wasn't a concern. This is simply just creating a way of filing that claim, which used to be a combination claim, without running afoul of the formalism of filing a coverage application. So I understand the implication, I think, of your question, Mr. Delaney, and I respectfully think it's making a mountain of a molehill. This is just the ability to allow people to claim something that didn't have a time limit without running afoul of the prior procedure that included some amending.
Okay, thank you, Mr. Frosch. Someone else?
I had one question. I can't, for rulemaking that we're working on, it's hard for me to think of both of you, Mr. Petrucci and Mr. Brody, were talking about that type of, I guess they might have a lease, primary resident issue where they let's say they live in LA and they have subletters, so they're like a mini landlord. What would you do if you were writing the laws to parse between that type of use of space, which, to prevent mini landlords from developing, versus just having a primary, someone who started out there and now has roommates and they've all been living there for 10 years and they're all together in the space. I'm trying to understand, is there anything, is it similar to that other issue where you had to keep it as broad, like relative, because it might relate to something down the line? As a lawyer, do you have to keep it as broad as possible, or is there anything we can do to differentiate between?
There's all the regulations as they exist already take care of the situation.
So you think-
Landlord could serve a 30-day notice and sue that tenant for non-primary residence in a court of competent jurisdiction.
Or, with the mini landlord type of situation, the privity regulations, talk about, who gets to be a protected occupant and who does not get to be a protected occupant, and talks about a tenant in occupancy and what happens when the lease expires and what the rights of recovery are or are not.
If that occupant moved in before the effective date of the law. If that occupant moved in after the effective date of the law, would not have independent rights.
You know, the more significant this fight, contest, if you will, is where you have a number of unrelated people living together. And, you know, is there a way that you differentiate between who does and who does not have a right, you know, and what are the implications going on?
Yeah,
You know,
I guess-
any landlord who doesn't live in the unit is an easy thing to answer, you know, depending on what it is you are looking to accomplish. You know, what is a harder thing to do is, you know, where there are a group of people living together, deciding what you as a board want to do about it, and what us as landlords and tenants advocates are therefore responsible for.
Okay, thank you. And also, Mr. Petrucci, could you clarify when you said that 30-day by the landlord? Because remember, again, these are landlords that rented to people
No,
who
the-
don't have a
the-
proper
the
CBO,
owner-
so.
You were saying that that prime tenant who wasn't really living there was just basically running a mini landlord
Yes,
operation.
I know of
The
some, yeah.
owner of the building would serve a 30-day notice on that.
But that landlord's the same kind of landlord that is not following the law. We're getting them on track to follow the.
That's what it means. Maybe a misunderstanding.
You know,
I guess I'm wondering why that landlord who's a loft law landlord that's already has renters that are living in a building that's manufacturing, and we're putting them on a pathway towards safety, public safety as an art, I care about that. I'm wondering why would that landlord try and get rid of the mini landlord? He doesn't even know what's happening in the building. I mean, just.
That's the nature of that's how the system works. If the landlord doesn't care, then there's no requirement. I mean, the entitlement, it's not that the tenant has to do it, it's that the tenant has to do it in order to assert a right. If the landlord doesn't really care what's going on in the building, then there's no issue.
With the subtenant who's living there.
Well, the subtenant who's living there would have other rights. Overcharge possibly, but if they did not have some independent protection, i.e. that they had moved in prior to the effective date of the law, they wouldn't have any independent claim. Then you would get into your constitutional issue of somebody who has no connection with the landlord post-law being able to assert some right. Unless the landlord was in cahoots. I mean, there are those cases
But that's door can be ghost.
where the landlord's in cahoots with that mini landlord, and they're sort of working hand in hand. And then the subtenant would claim that I'm really been accepted by the landlord who owns the building, therefore I have the rights of the mini landlord.
And if you go through the law court's privity regulations, you know, in terms of determining as between a tenant and a former subtenant, you know, who has the right, you know, part of the discussion also is, you know, what ultimately is the rent? And, you know, one of the benefits under those regulations, and I hate trying to figure out the math under it, is generally, you know, if the tenant does not have rights to that space and the subtenant is paying the tenant a rent that is somehow different and greater than what the tenant is paying to the landlord, one of the benefits that an owner gets in resolving that situation is that some portion of that increased rent inures to him upon him coming into privity with this now former subtenant.
I think all of it.
Pardon?
I think all of it.
Bob and I have done the math on occasion. You know,
The math is the Weisbrod formula for calculating the new rent for the prime tenant who gave up the space, who in effect had a negative rent because there was a profit. But the appealing thing to the owner in the privity of subdivided spaces was that all the rent that was being paid to the mini landlord.
If the space being recovered is an entire space, yes, you're absolutely correct. If, for instance, there are instances...
The adjustment is with the prime tenant, and the prime tenant gets to stay.
Yeah, or if the prime tenant has broken the space in a couple and he's in one space and his now former subtenant is in the other, and you wind up with situations where, you know, the landlord winds up getting good rent from the now former subtenant, but has a prime tenant whose rent is $100 or $200 a month. And that's talking to the 1982 1982 law more than to what would be happening under the current law.
And so as a related, and mostly probably in for Mr. Kozak, do you then have tenant versus tenant? A lot of tenant versus tenant cases where a leaseholder has sublet some space but then wants to reclaim that space and the subletters won't leave. Or there's some sort of, they want to put in their own claim, but the leasee wants the entire floor back because they want to, do something else with it.
Have I had those cases? Yes. Are they common? Not for me. In Smolka, which is one of the cases in your packet, that was my case, I represented the prime tenant in that case. The subtenant did not have any independent rights because she had moved in subsequent to the I have other situations where the tenant rented out, the tenants would leave, we ended up buying them out. I can't say that I've had a problem.
Just to have maybe one or two. The law board's rules currently have a structure for dealing with that. If the prime wants to recover the space, they have to do so within a certain amount of time. They must show it to the primary residence. They have to have a bona fide claim to the unit, and then they can recover it. I've had a tenant who, basically, we had a mini landlord of a floor, and then the floor had been subdivided into 5 different units, and the actual occupant was there on that day of the law, and she was entitled to her rights. The mini landlord could not recover the unit from her, and eventually left.
Obviously, I'm not really finding myself in a situation of representing the tenant, but I did try to find some cases that dealt with those issues. I found some small claims court cases, and it sort of speaks to another issue of when you have a lot of protected occupants, or at least more than one, and they're splitting the rent, they're still all jointly and separately liable for the full rent, absent some other mitigating circumstances, and you can end up with a situation where someone's just saying, I'm not paying the rent, but all the roommates that are paying rent have to pay the full amount, and then they may sue each other for recovering the unpaid rent, which can be difficult if it's part of the process.
Okay, thank you so much. I'm going to wrap it up here unless someone has some compelling question that must be said.
It's not a question, it's a thank you, Mr. Brody, Mr. Frosch, Mr. Petrucci, Mr. Kozak, thank you very much. Personally, it's been very enlightening, and I appreciate you taking the time out of your busy schedule to be here and help me better understand some of the issues.
Very good.
I think it's safe to say for all of us, if you need us on this and on other issues that you're wrestling with, we are glad to provide our insights.
Great. So you guys stole my line, so I'm going to say it anyway because I'm chair. So I want to let you, the gentlemen, know that we thank you very much. I'll vote for any one of you to be president. Right? As long as I'm moderating the debate. Thanks for coming here today. Thank you for volunteering and to come to discuss this very important matter. I see, from what I see, the tremendous preparation that you guys put into it. It touches me a little bit, so I appreciate it. You gentlemen obviously have spent many hours, days, and likely years, some more than some, right, dealing with this issue, and we are honored that you give so kindly of your time so that we can better understand this whole issue. All right, so we've come to the end of this board meeting. This will conclude our February 14th, 2019 Loft Board meeting. Our next public meeting will be held in March. What is this, February? We are in February, aren't we? Yes. February 21st. Sorry, I thought it was wrong. February 21st, 2019 at 2 p.m. at 22, right here at 22 Reed Street, Inspector Hall. Board members, please sign and hand in your attendance sheets. Thank you. Thank you.